Yes.
Lordship, item number 279, running in the supplementary list. Actually, what happened on the last day, that is on yesterday, the respondent bank served a notice and asked me to remove all the property which is lying with the property in question. This is my humble submission to Lordship. Kindly take the matter as per your urgency.
What is the order?
Order impugned is, the revision application is preferred against the order of order and final judgment of Honorable DRT. Against that order, revision application is preferred before the Lordship, and there is a CAN application for injunction.
Who is appearing for the other side?
Appearing Mr. Mukherjee, I already served the notice upon him.
Which Mr. Mukherjee?
Namta ki আছে? Pankaj Kumar Mukherjee.
Please serve a notice.
Sir, already served. Already served.
Come at 3 p.m.
Gratefully. Today.
Tomorrow.
Gratefully, Your Lordship. Grateful.
Item number 278.
May I seek my lord's kind to mention one motion of 2022 from the list and determination of my lord Justice Dinesh Kumar Sharma.
Yes.
My lord, the urgency is that, my lord, the impugned, my lord, I'm the decree holder, my lord, the decree has been stayed, my lord, upon direction for payment of contractual rent, my lord. And the, my lord, judgment data is taking time, my lord, on the plea, my lord, that the civil revisional application is pending before this honorable court.
Yes.
And, my lord, this
So what are the grave urgency? You cannot wait for
emergency, my lord, matter had appeared, my lord. My lord,
only the urgent matters which cannot wait till 14. Please come tomorrow. Yes.
May we permitted to mention one civil revision for eviction in the list? It was supposed to.
Yes, call the
My lord, may I be permitted to mention one matter from Justice Dinesh Kumar Sharma's?
Yes,
This
what
is
is the
item number
urgency?
238. It is a section 24 matter pending since 2024, and it is in the motion stage.
24 it is pending, you can wait.
It is in the motion stage.
Can wait. You have waited for 1 year.
And my lord, I'm begging for one more indulgence, my lord.
Yes.
It is running in the monthly list of item number 466 of your lordship. The petitioner is
What do you want? Upgradation?
It is an expeditious disposal.
You want
Yes, my lord.
upgradation?
Yes, my lord.
Please come
My
tomorrow.
lord, the petitioner is 77 years of
Maybe.
age.
Yes, call the list.
Grateful, your lordship.
কি আছে এটা? Yes, who is appearing in this matter? None appears for the petitioner at the time of
Upon instruction, my lord. Upon instruction, your lordship.
instructions, sir, you are mentioning for release, for instruction. You are a junior member of the bar, sir. You don't care to look into the matter and mention. I'm relying upon your submissions and passing orders. You're trying to mislead the court, sir. What is your name?
Tirupati Mukherjee, your lordship. Tirupati Mukherjee, your lordship.
How long you are practicing?
2 years, your lordship.
2 years standing practice, and now you are started doing this type of things.
Kindly makes a short pass over, your lordship.
No passover business. This matter
Lord, I'm appealing for the petitioner being laid by Mr. Parthopratim Rai.
But I need some more time. Well, Justice Shubham Mukherjee's judgment is not. I am unable to test it out. My lord.
On the,
There is judgment. I could not,
I also, my friend collection is also that.
but it is not probably my lord,
Not
report,
be reported,
you reported. That is the problem I am facing, my lord.
not be
Because-
reported.
Last week, my lord, if this week, my lord, I am also informed the others, so I can get
Uh,
hold of me. Otherwise,
এখনো পাওয়া যাচ্ছে না।
India কারণ না কোনো জায়গাতে
On the
Shubham
prayer of Mr. Rai, learned advocate for the petitioner, list from Mr. Mukherjee.
Certainly.
And if you get hold of that judgment, please,
I will hand over to your lordship and both Mr. Mukherjee and
please give it to Mr. Mukherjee in advance,
yes,
so that if he wants to make any submission, he can.
that
Yes.
is the point, my lord. Only that.
No, if there is a decision, Mr. Rai, because no decision has been cited directly on that point. So if there is some decision,
Only
yes, next.
Number 4.
For Lordship, in this matter, I am for the petitioner, Lordship.
Yes.
The plaintiff, Lordship, filed a suit for eviction and
What is this application for?
this is for expeditious disposal for
No,
preponderance of
can.
Lordship. Because Lordship, this was by order dated 28th of July, Lordship. It was shifted to Lordship monthly list of September due to urgency. I mentioned the matter, Lordship, and accordingly, Lordship, this application was filed. Now, Lordship, the plaintiff suit for recovery of khas possession and eviction, Lordship, against the defendant number 1 and 2, Lordship. In such a suit, Lordship, the defendant file and Lordship application for order 26 rule 9 that the mother plot in the RS Khotian, Lordship, is not the subject matter where they are staying. Now, Lordship, we accordingly filed an application under order 6 rule 17 for incorporation the RS plot and the corresponding Lordship LR plot. Your Lordship will find, Lordship, from the application order 6 rule
Give me
17.
a minute.
And along with that, Lordship, an application under order 1 rule 10 for making the party the concerned BLRO to the effect for bringing the record whether the mother plot RS plot is corresponding to that plot or not. That application, both the
For
application,
that, BLRO used to be a party, Mr. Sannal.
both the application was rejected, Lordship.
Rightly rejected.
Now, Lordship, kindly consider, Lordship, my
Give me
amendment,
a minute.
amendment application, Lordship. Page 26, Lordship.
Give me a minute. Where is the plaint?
Plaint, Lordship, has not been annexed, Lordship. I have annexed the Lordship because they have their defense was not, Lordship, that they are possessing, Lordship,
Where
1792.
is the plaint, Mr. Sannal?
Plaint, Lordship, I have amended plaint. I have annexed, Lordship, at page.
Amended plaint means after incorporating this.
No, Lordship. Yes, Lordship.
No, thereafter it was, prior to that it was also amended.
No, Lordship. Initially, it was amended after the thereafter, Lordship, after this filing of this application along with the amended plaint, I have filed the application. Now, the main
Where
plaint
is
has
the application for amendment?
page. Page 26, Lordship. Kindly come to, Lordship, page 26. The application was rejected because they have stated that in the cross-examination, I have denied they are possessing 1791 in the LR plot. My case is that the mother plot 1639 is, Lordship.
Sir, Sannal, you have sought to delete some paragraphs of the plaint. How that can be done?
Lordship, then but the schedule, only the schedule can be incorporated. If your lordship upon adjudication lordship come to finding that the said deletion is not necessary,
No, no.
but the schedule is lordship kindly consider the schedule in the arrest plot which is corresponding to 1792 or 1791, that is
Where is
lordship,
that case made out? Where is that case made out?
lordship kindly consider lordship I'm reading from starting paragraph number 1 lordship for the purpose of amendment lordship, that the original mother plot lordship 1639 lordship was splitted into lordship plot.
Mr. Shanral, this paragraph 2 will be deleted in its place. That cannot be permitted. That cannot be permitted. And if that is not permitted, the schedule cannot come.
Only the schedule portion, lordship, kindly
No.
consider lordship, because the others kindly come to the lordship order impugned lordship. Kindly come to the order impugned lordship. Paragraph number 5 lordship. Why the amendment application was rejected? Because lordship, the defendant categorically stated in my cross examination, I have stated they are not possessing one LR plot number 1791. My case is lordship that 16.
Where is the original plan? Why have you not annexed the original plan? You must be having the, how could you draft this civil division application, Mr. Shanral, without having the copy of the plan?
Original plaint lordship, I asked for lordship, lordship kindly take up the. I have asked that because lordship it's a long pending matter and change brief. Lordship, I have instructed the learned advocate before the court below to lordship bring all those documents lordship. Kindly lordship come to the lordship order
Give
impugned.
me a minute. And where is your application under order 1 root 10?
The lordship, its lordship started from page 36 lordship. Now it was stated lordship, kindly consider lordship that
I've seen those new LR plots. This
but lordship,
application
kindly
under
consider
article
the order impugned lordship. The RS plot number 1639, I want to change the lordship, it is 1792.
show me the foundational facts in the amendment application with regard to that.
Lordship kindly comes to lordship paragraph number 5 onwards lordship there.
Yes, show me paragraph number 5 onwards. Show me any basis of those new LR plot numbers. Nothing.
Paragraph number 6 lordship, I have stated
Yes,
lordship
I've
there.
seen paragraph number 6. Show me the foundational facts with regard to those new LR plot number. Nothing. This application under article 227
I am opposing this application.
Yes.
At the outset, I'm taking the point of maintainability. My lord, as the impugned order, my lord, passed on 11th of November 2024. And this civil revisional application, my lord, affirmed on 24th of July 2025. Now, no explanation as to delay is there, my lord, in the revisional application.
My lord, 227 application, my lord, the
27.
delay is to be explained, my lord.
No, you have not explained. Then
But even the 30 days, my lord, it was, order impugned was passed on 11th of November 2024.
yes. So
27 application, let me place on my, if your lordship kindly allow me, I can find supplementary evidence explaining the delay. My lord, 227 application, my lord. Ordinarily, no
you do
limitation.
not have a very good case on merit.
My lord, there's a very good case, my lord.
My lord,
Fight it out on merits.
Fine.
Yes.
it is
From my
fact,
file
my
by
lord,
Wakalatnama.
I have not come with my lord, this matter was moved with my lord, opening sentence that I have not come with a very happy facts, my lord. Because the second default, my lord, Party 7,
Second default.
7172 was filed, my lord. That was my lord, in time. My lord, the according
7172 filed in time.
in time, my lord. There was the adjudication was not required because according to the claim of the landlord, I paid in time. My lord, I paid.
Then what happened?
My lord, I'm telling my lord, from August 2011 to March 2019, I was a defaulter, admittedly, my lord, because of the plaint, according to the
You
plaint,
paid that amount.
Thereafter, my lord, April 2019, my lord, when the time of current print was came, my lord, at that point of time, the agitation come due to police atrocity in Howrah Court. That's why I couldn't deposit the current print. So current print became due, my lord. Thereafter, my lord, my lord, the COVID came and all this period, my lord. After that, from April 2019 to March 2022, my lord, I filed 151 application for depositing the rent. But that was absolutely my bona fide, but I was not in a position to deposit it. But I asked my client, my lord, to prepare a draft, my lord. He has drawn it, my lord, till date, my lord, with 10% interest. Because your lordship of April 2019, I was not in a position because the siege was started, my lord. There was no, my lord, lack of bonus.
Show me your 151
151
application.
application, my lord, your lordship will find in page 36. The plaintiff has filed this instant suit for eviction and recovery of first position against the defendant, and the defendant appeared before the Ranit Court on 30th November 2017 by filing Wakalatnama and an application under 71 and 70 of the West Bengal Premises Tenancy Act. The defendant begs to state that on 21/6/2019, after hearing the application under 72 of the West Bengal Premises Tenancy Act, one joint application filed by the parties to the suit, and then though no adjudication, my lord. The joint application was filed by the parties in the suit, and Ranit Court was pleased to direct the defendant to pay arrear rent of 60,720 as an arrear of rent from the month of August 2011 to March 2019. The defendant
So
begs
that
to state
Howrah Court, according to you, was closed from when?
from April 2019.
From April
2019. The incident happened on 14th, 15th, and my lord, on that time, from that time, my lord, it was closed.
So from more or less 15th of April 2019.
My lord.
And
My lord,
when did you deposit the
my lord, that,
amount on account of 71 and 72 earlier?
my lord, that was, your lordship will find the draft at page 40. 2nd of April 2019. That was a check to issued to the direct to the part. That was draft issued to direct to the parties.
Direct to the party.
Yes, my lord.
Not
That
in
is
the
at page
court.
40.
Not in the court.
No, my lord. Because that was a my lord, agreed amount. The agreement was, my lord, the parties came to agreement. So on that basis, my lord, page 40, your lordship will find Devraj Agarwal. It was drawn in favor of Devraj Agarwal.
No, where is their objection to this application?
To 151.
Yes.
My lord, the next, it is on page 43. Evasively denial, paragraph number 4. It is false to say the defendant could not deposit the rate before the Ranit Court due to the unavoidable circumstances, also as per the resolution of the Howrah Bar. It is known to everybody that Howrah Court Bar Association was.
Maybe the Bar Association was closed. We will not deposit in the Bar Association.
But the court was closed. No advocate was working. Well, kindly want to appreciate the thing. If the advocates are prevented from entering into the court and how the deposit can be, I'm asking to myself, my lord. My lord, I have, my lord, even if I.
Till how long that siege was continued?
My lord, perhaps till September.
Not perhaps. Show me from your
September,
application.
October. That has not been thereafter. My lord, what?
Then
My lord, thereafter, my lord, it is not possible for the client, my lord, to go every day to the court and to, my lord, know that when the court, my lord, my lord, this is the check, my lord, this is the draft, my lord, I have prepared for the till date, my lord. My lord, may I submit
that will
one?
not help.
My lord, may I submit
So
one thing?
show me specifically when the seize work started, when the seize work was lifted,
May I submit?
when you file this
May I
application.
submit one thing, my lord? If you lordship give me liberty, my lord, let me make a try, my lord, by putting it to the court so that it can be, my lord, for acceptance of this amount.
Where?
My lord, because the lord, try.
How? How that can liberty can be granted?
My lord, otherwise,
If you are
my lord,
entitled as per the law, you do whatever you
my lord,
do.
my
Don't
lord,
require
that period, my lord, the opening time, my lord, from April 2019, when the my lord, cause of action started, when I didn't file, my lord, that time, my lord, there was thereafter, my lord.
I want to know. I want to know till how long this seize work
My lord,
continued.
I've-
Where is your statement in the 151
I've stated that
application?
when I
When it was lifted, when you filed the second
thereafter, my lord, I
151.
was suffering, my lord, I'm a aged person, I was suffering from certain illness that has also been pleaded in 151
Maybe, but no
application.
documents in support of that.
But that has been evasively
Then,
denied. That has
then first strike, then your illness, then COVID.
well, kindly, the application is to be
Well,
explained, my lord. Not that thereafter I have not explained. But it facts, my lord, in court opened in sometime in September, October. My lord, the thing is this, my lord,
September, October
2019. 2019.
When did you file this application under 151?
2022.
So,
Well, the COVID period, well,
COVID period started when?
well, the Suomoto applications period was going on, my lord, at that point of time.
From when, sir? When this
From
order was
20
passed?
2020.
Yes.
Yes, but that is
So I'm asking you from
3-4 months.
Yes.
That's 3-4 months.
3-4 months is very vital, sir.
3-4 months, my lord, what I
3-4 months is vital.
yes, not
And that Suomoto writ petition period was extended in respect of those where limitation expired in that period, not prior to that.
kindly think pragmatically, it is not possible for a client to go every day to the court and to search whether the seize work is going on or lifted, my lord. It might be, and my lord, it has not been unexplained. It has not been unexplained. May not be, my lord,
So,
it has not been
did
supported.
not appear in the suit also thereafter?
Yes. Thereafter.
Thereafter?
No,
Yes,
my lord.
from October 2019,
No, my
it
lord.
did not appear.
No.
Where is the order sheet?
2022, my lord, final order I have given, but then I need to file a supplementary affidavit.
Yes, sir. What do you say?
Will kindly see from paragraph 4 onwards, internal page 3. Now, it's an admitted fact that 7-1 was not complied.
Not
Not
compliant.
complied. 7-1 was not complied, default since August 2011.
No, thereafter he has paid, he said.
Thereafter, my lord, according to his statement, from April 2019, he could not deposit because of Howrah Court incident.
Yes.
Now, my lord, the 7-2 application was disposed on 19th June 2019. So he's stating that the court was closed from April 2019. He could not deposit.
No,
but
not
the
April.
application was disposed of in June.
No, he said not from April. Yes, from April.
From April 2019.
Show me that
Paragraph 4, kindly see internal page 3, paragraph number 4.
internal page 3 of the
Revisional application, their statement, my lord. From 4 onwards, my lord, I will be placing till paragraph 8, my lord. It would be apparent from the record that the said application of the petitioner under section 7.2 of the Act of 97 was disposed of by the learned trial judge by order dated 21st June 2019. So, my lord, it's not that the court was not functioning. On the basis of the joint
from
application.
that you have paid this.
Yes, my lord. On the basis of joint application filed by the parties herein directing the defendant to pay 60,720 towards the area of rent for the period of August 2011 to March 2019. Now, my lord, when this application was disposed of on 21st June 2019, my lord, this August 2011 to March 2019 was calculated, and by this same said order, that is 21st June 2019, court had also directed him to make payment from June to
June onwards.
from April to June, also from April to June, and from July onwards, my lord.
Yes.
Now, my lord, will kindly see the next paragraph, my lord. The defendant, in compliance of the order of the learned trial judge, handed over to the learned advocate for the party demand draft of rupees 6720 issued by the Punjab National Bank towards the area of rent from August 2011 to March 2019. My lord, pausing here for the moment, my lord, even he has not complied the order which he has not challenged, passed on 19th of June 2019, by which 7.2 was disposed of, directing him to also deposit the rent, my lord, from May to June 2019, my lord.
That he has not deposited.
He has not deposited because 7.2 order was also there.
Show me the order under section 7.2.
7.2, my lord, in phone, my lord, I'm not carrying the hard copy, my lord.
Yes, you have not complied with that order also.
My lord, this is the operating portion, my lord.
And since you have paid, 7.2 does not say you have to deposit in the court. That amount in June pursuant to that order, you have paid directly to the landlord. What prevented you, what prevented you from deposit, from paying to the landlord?
May I?
7.2 also says,
7.2 was decided in June. There was a direction to pay till
It
April.
has
That
like
is
a
handed over to the advocate.
what prevented you from paying to the landlord?
The
Subsequent,
landlord didn't receive it. The landlord advocate on behalf of the landlord received the check on the basis of the court's order.
no. Court's order said pay to it directly.
That was 7.
Show me the
Madam,
court's order.
That was the. That was the agreed order. That was the order passed on an agreement between the parties. That was not the
Yes.
adjudication, my lord.
No, you have not said that I will pay directly. Directed to pay. Defendant is further
But-
directed to pay rent.
Well, it was,
Directed to deposit the current rent
it was not an
in court in
adjudication. my lord.
accordance with law.
But till April 2019, it was calculated
From
60,000.
April to June
Thereafter, from June to
to
July.
plaintiff.
Yes,
June,
madam.
my lord, there nothing prevented me to hand over the check to the landlord advocate.
April to June, you have paid to the plaintiff. April to June,
No, my lord, not paid.
From April onwards, I became a defaulter.
April to June also you have not paid.
But
That was directed to be paid to the plaintiff, not deposit. Not deposit.
7.1 application.
7.2.
Seven-
Yes, not deposited. Thank you.
Well,
sir.
let me deposit, my lord.
No, no.
Let's have cost may be input, my lord, but I will shut out by
No, no.
defense. From April onwards, they are my lord, completely, my lord,
Just give me a photocopy of
Yes,
that.
madam, I will.
but there are the complete, my lord, stalling of work in house.
Nothing. How could you pay that back to that?
The advocate accepted it, my lord.
Sir, this was also directed to be paid along with that order. So if you have paid that amount, what prevented you from paying from April to June? For that,
2 months, my lord. That my lord can be
extension, no
2
extension.
months, my lord, 2 months, 7, in the new act also, my lord, 2 months.
Yes, when did you pay for extension? Cannot be after.
But 2 months, my lord, even if the starting point of 2 months, there
Yes.
was a lapse. That can be, my lord.
Yes. So from June to 2 months, show me that you have paid within that.
June thereafter, my lord,
You have also not filed an application also that.
151 I filed, my lord, those in 2022.
This application.
I impose some cost, my lord, but the defense should not be, my lord. Kindly, my lord, I'm ready with the, ready with the draft.
Convince him he is willing.
I'm handing over right now.
Convince him if he is willing, I can, otherwise not.
And I'm handing over the draft right now, my lord.
Looking at the conduct, my lord, that they have not complied 7 on only the
Some cost maybe, some cost
What
maybe.
you say, because there was also a
So that
strike
is
in the,
correct, my lord, but my lord will.
strike in the Howrah court also was
Well, the
there.
suit of 2017, my lord, even they have not
I will
complied 7.
expedite the suit, but take instructions, come
My lord,
tomorrow.
I'll take instructions.
Draft I have issued, my lord. Issue I record that I am ready and willing to pay here and
Some
Lord, we have
yes.
My lord, I led by my lord senior Mr. Punashish Gupta, my lord. Today I am praying for some time, my lord, because
What happened?
yes, my lord, we do not receive the certified copy, my lord.
When we will get that?
On next week, my lord,
Next week,
next week.
the learned advocate.
That's, I don't think that is required, your lordship. Lord,
Uh,
last time I submitted before lordship that section 47 application is a time bar because it was filed almost after 20 years.
Said that you said that in the earlier orders, this application was rejected. Let me see that. Next week,
Next week, my lord.
next Tuesday,
Next Tuesday.
on the prayer of the yes,
As hard copy, my lord. They have received the same.
yes.
There is. Well, this is an application for recalling the further cross-examination of the PW1, my lord. That has been rejected against that order, I have come, my lord. But this is a fight between your brother and sister, my lord. Mother, my lord, gifted the property in favor of the sister, my lord, on that ground, my lord.
Who is appearing for the respondent?
Respondent not appear, my lord.
Every service filed in court today is yes, Mr. Rai.
Extension of interim order.
Extension of interim order.
To appear on behalf of opposite party in both the cases.
It is not there in the list, my lord. It is not there in the list. I mentioned.
Yes, what is this issue? You are appearing
Preemption.
for the opposite party. What do you say?
Preemption. Well, I am
Sir,
ready.
what
To,
is
I am ready to do this, my lord.
you are?
Ready, but by limitation on the face of it. If your lordship clearly consider, but by limitation and the preemptive petitioner, if your lordship allowed the application.
Yes, are you ready?
Today is for extension, but yesterday night, I got.
Yes, I may.
Yesterday night, I got a call.
Uh,
Let this be extended.
every service filing.
No, it is just earlier. Earlier it is extended in the presence of my learned friend. So that's why.
The interim order. Eight and nine, Mr. Rai, two matters.
Yes. Eight is the initial, eight is the initial matter, where it is admitted and the execution not been filed. Subsequently, on the filing of the execution, I prayed for stay that was refused against that.
Yes, next. 10 years.
I am appearing on behalf of the petitioner. Mr.
Lord, I am-
Chatterjee is leading me.
I am opposing this. There, my lord.
Milord, before Milord, I open up my case. Milord, in the last order, there are Milord, two minor Milord typographical Milord corrections which are required.
Yes,
If Milord kindly take Milord the last order passed on 29th of July 2025.
yes,
Milord, third page, internal page 3, first line.
yes.
Milord, on an application under order 39, Milord, instead of order 39 rules 1 and 2, this should have been Milord order 7 rule 11. Milord, that's indicated in the last line also.
Page, internal page.
Internal
3,
page 3.
on an application under order 39 rule 1 and 2.
No, Milord, this was under order 7 rule 11. Milord, these are the two corrections, Milord, which I did. Milord, I have just indicated.
Order 39, rule 1-2
Should have been order 7 rule 11.
was filed in the appeal. And that is pending hearing.
Yes, yes. আচ্ছা এটা এরকম হচ্ছে কেন?
will tear it out from the I'll tear the back sheet out and I'll make it over to you.
এটা কিন্তু এটা দেখুন কি ব্যাপার। The petitioner draws the attention of the court to a type.
There.
So therefore, the court, my lord,
And my learned friend, here and now, my learned friend suggested that we did not move because the High Court is in session of the matter. That's what he has submitted right now.
interim
Don't get
manager
agitated.
this is not
It's only 11:15. You have the entire day to go. Please don't get angry.
This aspersion is on me.
It's not an aspersion, my lord. Yes. But I am clarifying myself. Since Mr. Banerjee is so angry, I am clarifying what I have submitted.
Mr. Rai, please give me a minute.
কি ছিল লাস্ট দেখি ট্রায়াল কোর্টের কি অর্ডার হয়েছে
Next date fixed.
but 10th of September milord I am told
September it is fixed. And my lord, so far as the
Mr. Rai, it was not there that they did not because the court
was not
was of
uploaded.
the view
Yes.
that the order was not available in
uploaded.
the
and milord,
website.
nobody was there from their end in
No, no,
courtroom
both sides were present, my lord.
but he was
My lord,
present
no, no, in that
second
event, but if your lordship sees the order sheet.
Ah.
Now, my lord, so far as temporary injunction is concerned, my lord, I have some submission, my lord.
Yes.
My lord, in this matter, my lord, the temporary injunction cannot be granted. My lord, my humble submission is because in the appeal under rejection, in connection with the rejection of a plaint, my lord, when the plaint is not existent, my lord, there cannot be any injunction order in that plaint. My lord, that is my submission.
Against that, an appeal has been filed.
Appeal has been filed.
So if the appeal that is set aside and in the meantime.
My lord, my submission is, no, my lord.
I'm directing on the 9th, 10th of September, this matter will be, I'm extending it for a limited period.
And my lord, this interim order, my lord, which has been passed by your lordship, may not influence the judge below.
That I think
Because I have
that in the earlier order.
that is there, my lord. your-
Clarified that and I've
And
because
what-
this order was passed on 29th of July
yes
and that order I've clarified.
And another, my lord,
that
your lordship
clarification is
my lord,
there.
my lord, another
Will be free
clarification
to
is
without being influenced by the fact that
Yes,
this
that's
there
there.
it's there
My lord, I am asking for the further. And my lord, another thing, my lord, they are
they are disposing of the civil division application.
Lord,
can you keep it pending I don't know what's going to happen on 10th very well
Then again a confusion will arise.
very
It's pending, it's
very well milord
And my lord,
Very-
one submission, my lord, what they are doing, my lord, their injunction, my lord, your lordship has also observed on the last occasion, my lord, it is on 0.14 cents.
yes.
It is a 52 kathas of land, and my lord, they are
That
not,
is only on 0.14.
That
I've
one is-
mentioned that.
my lord, your lordship has not clarified the, my lord, what they are doing.
No,
They are reporting to the police.
Mr. Raj,
That injunction is-
required, its injunction is only with regard to a particular.
My lord, one line clarification, my lord.
it's limited to that extent only
Lord will,
I've said, I think I've clarified that.
yes milord
no, your
my
lordship,
lord
yes,
seen
your
milord the
lordship
interim
will-
order my lord has seen milord the injunction order which has made absolute
After
by the
noting
trial
that I
court.
have recorded,
Your lordship has quoted your lordship has quoted the injunction order, my lord,
Yes.
which was passed, my lord, in the court.
yes.
But my lord, I'm humbly praying before your lordship, my lord, kindly clarify that because what is going on is something else. My lord, they are, my lord,
This is
interpreting it.
bar. This is milord from the bar
Nothing is from the bar,
yes
then his
absolutely
submission is also
milord
from
he's
the bar.
making some statements milord
What
on
is going
facts
on there? There,
milord let him say that milord
They are
milord
Uh,
will
Mr.
deal
Rai,
with that
please kindly come to page 5. Maybe the page may not be telling. I've said from the suit property, dispossessing the petitioner from the property mentioned in the schedule of the plaint.
correct
That is
of the
0.14.
plate. That is there.
So
What they are doing, my lord, they are, my lord, two connection petitions are there. What is going on? They are influencing the police
Huh?
that we have injunction and they are not allowing us to enter into the enterprises.
You-
Well, it is an auction purchase.
make it
property.
stand clear what
If your lordship gets into it, my lord, this property, the erstwhile, my lord, his predecessor.
all right, this application, this matter,
That thing, my lord.
this matter was mentioned for extension of interim order. Better dispose of. Yes, call the next matter.
11 lordship in this matter, Mr. Sivasis Chatterjee is appearing lordship due to illness, fever. He could not come to court.
12. I'm appealing for the petition.
11.
11. Okay.
11.
Now, lordship, I have requested by him lordship to pray for an adjournment before this. Mr. Sivasis Chatterjee lordship could not come to court.
On the prayer of the, on the prayer.
Well, I am appealing for the petition.
Yes.
Well, petitioner before Rossip Malad. This is affidavit service.
Yes.
Is a lessee of a premises number 20 Abdul Hamid Street. Well, a portion of the said premises was for the office purpose. It was leased out in the year of 1983.
You are the defendant
Defendant in the yes, Malad.
in the suit.
Suit. And
What is
Malad,
the
I
suit
was
for?
a suit for declaration.
Declaration of what?
Tenant, as he is a tenant.
Declaration of your tenancy right.
My lord. Not my tenant.
His tenancy
My
right.
lord.
Yes.
And
Then-
my lord, in that suit, my lord, when everything is over, evidence was concluded. And thereafter, my lord, sometime in the
It was concluded.
yes, my lord. Thereafter, they filed one application for amendment plan. Before that, what they did, my lord, lordship would be astonished. One check suddenly was issued by the plaintiff in favor of the defendant, and without mentioning anything that it is a lump sum amount 51,000, you accept it. It has been returned back. Thereafter, my lord, they filed one application for amendment of plaint that was rejected by the learned court below. Then, my lord, surreptitiously they moved the civil divisional application before the Honorable Court without serving us the copy, obtain ex-parte order, and, my lord, been misleading the court, obtain an order. Thereby, my lord, the plaintiff was allowed to file fresh application for amendment of plaint. In that fresh amendment of plaint, my lord, in that amendment of plaint, they have introduced a new case. Totally new case. Earlier amendment of plaint and now the amendment of plaint. Both the applications have an annex here. Lordships, kindly have a look to the page 60. My lord, old amendment application is at page 55. Lordships, kindly come to page 55 first. Introduce a new case. My lord, this is a page 55 old amendment application. What they have stated, my lord, this is a suit for, what is the suit for? Thereafter, my lord, this is paragraph 4. Page 56. During the pendency of the suit, plaintiff sent a rupees 51,000 on account of rent to this defendant. Without mention, one check is sent, just mention the premises number, not the particular portion even. Together with forwarding letter dated 6/12/2023 under speed post to the addressee of the defendant, and this defendant was duly served the letter along with the said check. However, subsequently, the defendant returned the same reason whereof the base note to them. Xerox copy of the letter, check. The plaintiff intend to brought the aforesaid facts into the plaint as subsequent evident by way of formal amendment as mentioned in the schedule proposed amendment herein below. This application shall not change the nature. What they, thereafter, the learned court below passed an order, losses can page 61. May I point to read it. Today is fixed for passing the order in respect of an application dated 18 January 2024, filed by the file under Order 6, Rule 17, read with Section 151 of the CPC. Both the parties filed their respective memos of appearance through their learned advocate.
This was rejected.
Yes, this was rejected. Against that, they surreptitiously came before this Honorable Court and they obtained an order that to file a fresh amendment application. This was rejected. Losses kindly the last portion. I am maybe on page 62. Defendant filed written statement on 27 February 2013 and subsequently same was accepted such and such. I'm just operative portion. I'm just thereafter evidence of PW1 as well as the evidence of DW have also been concluded and date has been fixed for hearing of argument and filing of such application for further incorporation of the fact making payment after a long lapse of 11 years is nothing but a way of dragging the matter, and furthermore the citations are not applicable in the suit as such. I am not inclined to allow this application. Thereafter, they moved a civil divisional application surreptitiously without serving us the copy, and they obtained an order page 65. Here also, losses in misinterpreting this order, they have filed an application for amendment of plaint. Malad, may I be permitted to read it? This is a long order. Anyway, I'm just reading the operative portion, page 66. In such view of the matter, I find that present application can be disposed of, giving liberty to the plaintiff to make a fresh prayer for amendment before trial court, since the order going to be passed by this court is not likely to cause prejudice to the plaintiff. How, my lord, this is not possible. Party herein, the service of the copy of the application of the party is dispensed with. The present application being such and such is thereby disposed of, giving liberty to the petition to prepare fresh application for amendment plan within a period of 30 days from the date of communication of the order. In the event the filing of such application, plaintiff before the court below, the court below will give opportunity to the defendant objection with reasonable period. Thereafter, will dispose of the same. My lord, thereafter, on the learned court below, without giving us any opportunity to file the objection to that amendment application, passed an order under challenge before the lordships, my lord. My lord, in that fresh amendment application, if your lordship kindly come to page 71, my lord, page 71, what they are proposed to amend, my lord, this that is also, my lord, indicated. Lordships kindly see. Upon hearing the revisional application, such and such, the Dr. Ajay Kumar Mukherjee, the Honorable Justice Dr. Ajay Kumar Mukherjee passed the following order. My lord, thereafter, my lord, the proposed amendment. The present page 74. What they are going to incorporate in the plaint, my lord. Page 74. Schedule of the proposed amendment. My lord, before earlier amendment, my lord, that is at page 51, page 57, and my lord, this is, my lord, 74. The present amendment application, page 74. Earlier amendment, my lord, that is page 74. Page 51, 57, my lord, sir. Page 57. My lord, here earlier application, my lord, if you only come to first page 57. My lord, I'm sorry that I have already skipped that particular portion. Page 57. That is earlier schedule for amendment.
Yes.
My lord, page 57, lordships, kindly have a look.
57.
57, my lord.
Yes.
There was the earlier amendment application, what they intend to incorporate. That's my schedule of proposed amendment. Well, the plaintiff duly sent a sum of rupees 51,000 only on account of due rent to the dependent through check, and the dependent duly accepted same, however, subsequently returned the said checks. Under this, it is humbly prayed, your lordship will be pleased to amend the plaint in terms of the schedule. Now, my lord, what they have introduced a new case, that is, my lord, page 74. After paragraph 10 of the original plaint, the following should be added as paragraph 10A. That being the tenancy initially had made with the Mrs. Tara Devi Kedia, and accordingly the rent on a religious basis paid till December 1982. So her tenancy agreement is still valid since no NOC have been taken into consideration while initiate fresh lease with Messrs. Shupul Construction Private Limited, where Mrs. Tara Devi Kedia was neither a shareholder nor the director of the company at that point of time. Next, that the fresh registered lease deed had made up 25th January 1983 with Shupul Construction Private Limited for a long term for 30 years or more, with the interest being security deposit of 2 lakhs, 20,000, sorry, 2 lakhs. 20,000 received on 25th January 1983. In case of non-payment of the huge amount along with interest, holding more than 40 years should be discharged first before claiming and vacation of the premises. The defendant is silent completely on such matter of causing major financial irregularity on their part. The plaintiff duly sent a check, a sum of 51,000 only on account of the due rent to the defendant through account pay check, but the defendant, after receiving the same, subsequently returned the same check to the plaintiff without any rhyme and reason. This is the proposed amendment. My humble submission before the last is, 1983. It was a fresh lease, registered lease upon the plaintiff, my lord. And it has expired in the month of December 2012. Before that, we served a quit notice under the TP Act. And then, my lord, immediately after serving the notice to quit, they filed the suit for declaration as a tenant. And, my lord, in that suit, let's say I have also annexed the plaint. Their claim is that they are claiming the tenancy. And since 2013, my lord, 1st January, they are not paying not a single amount, not a single paise after expiry. And my lord, after my lord, lapse of 13 years, they are sending one check. And my lord, suit is when at the final stage of hearing, they are coming with a new facts.
Yes,
Milord, kindly have to, before my friend, I take the party to mention one thing. My learned friend has told the other side surreptitiously, which I am strictly objecting on that.
no, I could not follow you.
Before he starts his opinion, he said surreptitiously we went to the High Court before the learned Honorable Judge Ajay Mukherjee. It is not a correct statement of facts. That is one. Number two, have they had any objections at that point of time? They could gone to the SLP. Why they have come today? And today they have accepted everything. They have the case is not maintainable at all. 136 is very open to them. They have not done. And then 51,000 is the case. If the 51,000 is the fact, that has been told in every places. And why they have rejected it, they have returned it, they have not given any iota of reasons and instructions also. That because of this reason, I'm not taking into account. So then my learned friend I'm taking, he will hand over and tell.
Yes.
Milord, thing is this, Milord. My Lord Justice Ajay Mukherjee granted leave to file a fresh amendment application, Milord. On the basis of that leave, Milord, I have filed a fresh application, Milord. And Milord, application, I have just pointed out the actual fact, which is after the argument. I have sent the check.
After the argument,
No.
the
evidence.
after the evidence, I have sent the check.
Of
After the evidence, you have sent check.
No. Check.
That you have said after the evidence, you have sent check.
No. The data, data. Check it, data.
All right, you can proceed. Yes, you have sent a check.
Send the check. They have returned it. Only that fact I want to incorporate. Nothing
Only
more,
that
nothing.
fact.
Only that fact and some other place that I have paid some amounts. Only 2 and 3 paragraphs, Milord. That will not prejudice him, Milord. My question is that how they will prejudice. They have returned. I want to incorporate that. Nothing more, nothing less, Milord. And there will be no prejudice. And Milord, my Lord Justice Ajay Mukherjee
Has granted leave.
granted leave. For that reason, I have filed
At what stage? All evidence has been closed, so it's at the argument stage.
argument stage. That is thing. But since there was a leave, Milord, so
Pursuant to the leave, liberty granted, you have filed that
filed
application.
that application.
Thank you. Anything in reply?
Reply, my lord, pursuant
Not on facts.
any, my lord, even pursuant to the liberty, if
All right. This application Next matter. Yes.
Suit for permanent injunction, Lordship. Petitioner is the plaintiffs.
Few allowed. Few stands allowed. There were observations and directions. Few stands allowed. Yes, yes. What do you want?
Lordship, expeditious disposal since the
Of
order
what?
39, Lordship, order 39, rule 7, along with
39 rule 7 and
with order 1 and rule 10, both are pending, Lordship.
order 1 rule 10.
Both are pending on and from 27/6/2023, Lordship. And next date has been fixed
This
by the learned
application under Article 220, this
1711.
application under
Title suit, Lordship. Suit for permanent injunction, Lordship.
what are the applications pending?
Lordship, the case record has been transferred on 12/11/2020.
Substituted defendants, steps have to be taken.
On this year, Lordship, no date has been fixed. Last date was fixed on 20/11/2024. Since then, case record has been transferred, Lordship.
No, that is one thing. Have you taken steps upon the substituted defendants? Have they appeared?
Appeared, Lordship.
When did they appear?
Long back, Lordship.
No, no, no. Substituted defendants. The date was fixed on 28th of April 2025 for taking steps. What happened after that?
On 12/7/2024, Lordship, they appeared.
Not 2024. Madam, when they appeared?
12/7/2024, Lordship.
No, steps. We are directed to take steps on by an order dated 22nd of July 2024. And it was fixed on 28th of April 2025 for taking steps upon the substituted defendants.
Lordship, thereafter,
So you have not
no
taken
date-
steps.
2025, Lordship, no date has been fixed since the case record has been transferred from the Court of the Learned Civil Judge Junior Division First Court. Lordship, Lordship, kindly come to order dated 12/11/2024, Lordship. Appearance of the parties before the Learned Civil Judge Junior Division Second Court, Barashat, not 24 Parganas. Yes, thereafter, Lordship, 2025, no date has been fixed. Thereafter, on
No
inquiry.
date has been fixed for 2025.
No date, Lordship.
This application under Article 227 of the Constitution.
My lord, I appear for the petitioner here, my lord.
Yes.
Respondents, they have not been served yet. my lord. I can come back after serving, or my lord.
My lord, I came to know from the causes that the matter is running.
All right.
And my lord,
Let me see, I'm coming after 5 minutes. If you have an extra copy, please give it to him.
Just in the course of the day, I will serve the copy, my lord.
Don't have an extra copy.
We do have a copy, my lord, that needs a slight amendment.
So that we can look to that. I'm coming after 5 minutes.
I appear for the opposite party.
I'm for the petitioner, my lord.
Yes.
As I was saying, we have not been able to serve them the hard copy, but we do have a soft copy of it. I've had a word with the council.
Yes, what is this matter?
Yeah, my lord, the impugn order is at page 34. Essentially, this is about a mortgage contract which has been arbitrated and put into execution. Now, amongst other things, my main ground is mortgage contracts are non-arbitrable. Therefore, any arbitration done on that and any execution is null and void. And that is precisely what is going on before the Learned Commercial Court, Alipur. And this is despite a suit pending before the City Civil Court and an injunction therein. And we filed, my lord may see, it is at page, IA is at page 40, Annexure B2. At paragraph 3, my lord, we have taken the ground that mortgage contracts of residential property.
Which?
Page 40 of the IM, of the petition, Annexure B2, my lord.
Yes.
My lord may notice that at paragraph 3, we have stated clearly that mortgage contracts are not arbitrable there. The subject matter of residential mortgages are not
Where is the award? Where is the award?
The award is at, my lord, give me a second, my lord, please. Perhaps my learned friend there would be able to assist my lord. I am not able to see the arbitral award there.
Yes.
In addition, but essentially that it is against that arbitral award which has been put into execution. We are before my lord, and this is the main issue amongst others. If my lord can take a view on that.
Where in this application?
I beg your pardon, my lord.
What is the prayer in your application?
To dismiss the execution application proceedings, or pending that, a stay be granted in the.
No, where is your prayer? Which page?
It is.
Page 13, madam.
You have said for rejection as well as return. How can both these two things go together?
That was the prayer in the IA, my lord. But
yes, in the IA which was disposed of. So you have paid for return. Return
as well as rejection as well, my lord.
Yes.
As well as rejection, my lord.
So show me your grounds of rejection. Show me what grounds you have taken for rejection.
The grounds start, yeah, my lord. The grounds is, starts at page. Yes, my lord. In the IA, it's at page 40.
Yes, show me the grounds which you are now saying. Those grounds are not there in the application.
It is at paragraph 3, my lord.
Yes, paragraph 3, what has been stated?
Yes.
Has obtained an ex-parte award. Have you challenged that award?
Yes, that is also pending before the Learned Commercial Court in Alipur. And,
so
and
file an application for stay there.
No, we have filed for stay as well. But the problem is, and this is something surprisingly which is going on. The moment we say that 34 should be decided first,
yes,
that it is pushed back to a long date, and then in the meantime execution continues. And
yes,
this is despite full knowledge of the court that the same thing has been challenged in this in the 34. And ironically, my lord, it's the same arbitrator doing multiple arbitration before that commercial court, my lord. The arbitrator in that case, my lord, is a routinely appointed arbitrator. And that has also been mentioned in the petition. The
Those
number
are
of
under section 34. You agitate all your grounds under section 34.
Yeah, we have, my lord, but parallel proceedings in execution is also to be discouraged, my lord, because they are issuing threats of warrant of arrest.
Stay there. You can pray for stay there.
That's the problem I'm expressing, my lord. The moment we are praying for a 36 stay, it is not being heard. At least a direction be given that 34 be heard first, and then this execution proceedings be continued. Otherwise,
if you want, I can direct the section 36 when it is being fixed. I can direct that, but I will not direct do this before, do that after. No.
The reason is the connected matter, madam.
I can give you liberty to apply for taking up the application for stay. That much I can do. But
that is fixed on the 9th. That is fixed on the 9th of September, my lord, 2025.
9th, you move your application. No difficulty on that.
What is going on in the meantime is, my lord, they are pressing for arrest warrant for 2 ladies, and it is very clear in section 56 of the CPC, if my lord can take it. A woman cannot be arrested. Now, despite knowing this, these things are being pressed on in the court, and on the same day, what is going on at unusual hours, unknown men.
By this order, no arrest warrant has been issued. By this order,
but yeah, they were in the subsequent orders, my lord.
Subsequent orders is not under challenge.
No, we have made an application there.
Maybe
we have made it clear.
So subsequent order is not under challenge. So only this order is under challenge.
But apart from anything else, my lord, the issue is legal in nature. It's a law point whether arbitration mortgage contracts can be arbitrated. That's the main issue, my lord.
By consider it gives us at least 1 or 2 days. Let them serve us a copy. We will come up with better particulars to assist, my lord.
All right.
And my lord, Supreme Court is clear on that. The mortgage contracts cannot be arbitrated.
No stay. When this matter is taken,
at least 34 be directed to be heard expeditiously, my lord, before this one. Then whatever would be my fate.
Not before this. When this matter is taken up for hearing, the learned advocate appears and submits that he has instructions to represent the opposite party. The petitioner is directed to serve a copy of this application upon the opposite party and file an affidavit of service on the next date. List this matter under the heading motion. How soon can you serve?
Yes, ma'am.
How soon can you?
Within 2 hours, my lord.
In the course of research.
So
before my lord concludes, may I, my lord, may I, my lord, take you to page 5, just for 1 second, my lord. Page 5 of the petition.
Yes.
My lord will see, with regards to just one mortgage property, that NBFC has filed multiple civil and criminal cases, and these are 2 elderly widows.
Yes, please serve, then come. Yes, next.
Grateful, my lord.
Deep level.
My lord, this case has a checkered past, my lord. What has happened, my lord, in this matter, my lord? My client, being a defendant over there, my lord, petitioner before the lordship, my lord, had filed one partition suit in the year 1985, my lord. I have given the chart, my lord, which the lordship kindly take pen to go through the chart, genealogical table, my lord. That is at page 23, my lord. Lordship will find 23, my lord, page 23, 2-3.
Yes.
Genealogical table.
No. What is the impugned order?
Impugned order with regard to, my lord, my client has been kept dark by the advocate, conducting advocate, who in collusion with the other side had allowed to have the suit ex-parte hearing, my lord, without filing any WSU. Though ample opportunity was given by the court, he didn't inform me. I, being a lady, my husband is suffering, is totally confined to bed, my lord, because he is also authorized patient, my lord. So fully dependent, I used to come before the home of the petitioner and collect his fees, my lord. Totally kept me in dark. So thereafter,
But the
what
order-
happened, my lord?
The order
My lord, I beg to appear on behalf of the petitioner, my lord. I beg to appear on behalf of the petitioner, my lord. The petitioner is aggrieved by the order dated 16th April 2025, my lord, passing misc case number 54 of 2024, my lord. The case of the petitioner is, my lord, the petitioner are the Thika tenant, my lord. They are submitting return before the Thika controller, my lord. The challan is annexed page number.
What is the miscase for?
I am coming to that point, my lord.
What is the miscase for, sir?
My lord, I am coming to that. We are the Thika tenant, my lord. We are
Sir, what is the miscase for? Please take me there.
opposite party file a suit, my lord.
Yes.
The suit by decree Ex-parte, my lord.
Yes.
No summon by received, my lord. We have no opportunity to file
It is for order 9 rule 13.
my lord.
Yes.
My
Tell
lord.
me that. So order 9 rule 13.
My lord.
When the suit was decreed ex-parte.
On 11th December 2023, my lord. That has not been annexed with the civil revision, my lord. The copy of the.
When you filed order 9 rule 13.
এই কবে ফাইল করেছো? এটি অর্ডার 9 রুল 13 কবে ফাইল করেছো? এখানে তো কোনো ডেট পাচ্ছি না। 10/7/24 10th of July 2024, my lord.
10th of July.
There is এটা তো রিসিভিং ডেট। তোমার তুমি তো আদার সাইডে সার্ভিস করো। When you have filed.
Yes, what happened? What is the impugned order?
My lord, by the impugned order, my lord, my misc case have been rejected, my lord. There is execution case, my lord, that is
rejected.
My lord.
Where is that?
The impugned order is, my lord.
Show me the miscase was rejected. If the miscase is rejected, it appeal lies, sir.
My lord, the prayer for interim stay on the operation of
rejected, not the miscellaneous case.
My lord. I'm so sorry. In connection with the execution case is rejected.
What happened on 10th of July 2025?
10th of July 2025. The matter, my lord, I am coming to the one point, my lord. The matter if it being proceeded before the Thika tenant, my lord. The opposite party is also.
What happened on 10th of July 2025 before the Lanet Civil Judge Junior Division Second Court?
My lord, I have engaged in this matter today only. এই ডেটে কি হয়েছে? No information, my lord. No information. What happened on the matter is fixed proceeding being before the Thika tenant, my lord, where the opposite party is also a party.
If you are not ready, if you want time, I will give you time.
My lord, this is the Thika property, my lord.
Sir, I cannot decide that now. The impugned order is rejection of a prayer for stay.
My lord,
of the title execution
the
case.
civil court have also no jurisdiction after the coming of the Act of 2001, my lord. This is the.
Sir, are you ready? If you are ready, make submissions. Please answer the questions which I am putting to you.
Kindly, I pray for note today, my lord. Can it be taken tomorrow?
The learned advocate appearing for the petitioner submit
it will appear before.
Yes, next. All the next matter.
My lord, in this matter, my lord, I am appearing for the petitioner, my lord. My lord, here, my lord, I have challenged the order of the learned district judge Howrah, my lord, in miscellaneous appeal number 78 of 2025, my lord.
Yes.
My lord, if your lordship kindly comes to the,
Who are you in the suit?
my lord, I am the plaintiff, my lord.
What is the suit for?
My lord, the suit was for, my lord, title suit, my lord, for the tenancy, my lord, and permanent injunction.
Declaration of tenancy right.
My lord, I am a tenant, my lord. If your lordship
Yes.
kindly comes to
Where is the order of the trial court?
my lord. My lord, page 64, my lord. It starts with page 64, my lord. 65 with the judge.
That is the appellate court's judgment. Where is the trial court's judgment?
My lord, at the last, my lord, certified copy, my lord.
So last certified copy is the appeal court's judgment, sir. I want the trial court's judgment.
My lord, page 42, my lord. Page 52 is the order, my lord.
Yes.
My lord, I am relying on a judgment, my lord, coordinate bench judgment, my lord, passed by this honorable court, my lord. Your lordship,
For what proposition?
my lord, regarding the, my lord, extinguishing of right, my lord, of the tenant, my lord. If your lordship kindly comes to para 14, my lord. My lord, may I read, my lord? Para 14 of the judgment, my lord.
Yes.
The tenancy right is a heritable right under the West Bengal Premises Tenancy Act 1956, and as such right cannot be extinguished on the death of the original tenant. Tenancy right can be extinguished either by surrender of tenancy by the tenants or by eviction of the tenants by following the due process of law. Since the plaintiffs claim that the tenancy which they inherited from their predecessors has not been extinguished by any of the modes recognized under the law, they are still tenants in the suit premises, and merely for non-payment of rent for certain period, the tenancy right in the suit property cannot be extinguished. But if your lordship kindly comes to para 16, my lord, be that as it may, the plaintiff themselves have admitted.
You will not be relying upon paragraph 15, last 3-4 lines.
My lord, deeply obliged, my lord.
Thank you.
Thus,
Yes,
though
please
this
place that.
Thus,
The 15 last 3-4 lines.
thus, though this court finds that the plaintiffs have made out a prima facie case in support of their claim for tenancy right in the suit premises, but their possession therein, as on the date of filing of the suit, is doubtful. As no material showing their possession therein, as on the date of filing of the suit, has been produced. Be it as it may, the plaintiff themselves have admitted in their application for contempt that the entire building has been demolished completely by 26 May 2009. Thus, admittedly, the suit premises is not in existence as on today. It is true that even if the premises is demolished, the tenancy right of the tenant does not evaporate automatically, and such right will stand restored and or revived whenever the building is reconstructed. Thus, if the plaintiffs ultimately succeed in proving that they inherited their tenancy right in the suit premises and their tenancy right has not been extinguished otherwise, then their tenancy right will revive with the reconstruction of the new building therein. Malad.
Yes. You are relying upon this judgment.
Malad.
The learned judge of the appellate court also relied upon this judgment.
Malad.
Yes, what is your submission?
Malad, my submission is this, Malad, that in the year 2009, Malad, the suit premises was demolished, Malad. And Malad, we were Malad forcefully evicted, Malad. Malad, now Malad, the contention is this, Malad, that Malad, if a new building is Malad reconstructed, Malad, then Malad, at least my right should be extinguished, Malad.
Right should be extinguished.
Malad,
What are you saying?
Malad, my right should be protected. Malad, I should be protected, Malad.
This application under Article 227 of the Constitution of
Case number 19.
This is my application, my lord. Challenging an order dated 28 July, dismissing my application under section 47 of the Code of Civil Procedure.
Subject to question, my lord, before my learned friend starts, taking leave of Mr. Ghosh. Probably.
This is also appearing.
Yes, yes.
Yes.
In this matter, connection with this matter, my lord was there, well, appearing on behalf of the state, but same execution proceedings, same matter between the parties. It is my duty to point it out. Apart from that, I have nothing to say.
State is the party here.
Yes.
Since it
That
has
is why.
আগে করে দেবেন তো।
Actually, item number 21, I'm praying for expeditious disposal of the
Of what?
title suit number 1 of 2017.
What is the suit for?
The suit is for declaration of title and permanent injunction and for declaration that deed number 10673 of 1982 is.
What is the stage of the suit?
Lordship, it is in the evidence stage and the next date is fixed on 3rd of November 2025.
Evidence of whom?
Uh, Lordship, it is in the evidence stage, but it is on hold because it is the report from the fingerprint bureau is pending. And for that, your Lordship.
Report of?
From the fingerprint bureau, Bhavani Bhavan. That is pending, your Lordship. On 6 consecutive dates, it has not been given.
Fingerprint expert.
Yes, your Lordship. We had filed an application under Order 26, Rule 10A that has been allowed. The petitioner's fingerprint has been taken and it has been sent to the fingerprint bureau, Bhavani Bhavan. And it is awaiting report.
Item number 22.
Item number 22, I beg to appear on behalf of the petitioner, my lord. It is a expeditious disposal of the matter.
Of what?
Of a partition suit, my lord. Partition suit.
What is the stage of the suit?
The plaintiff have filed written objection against the 151 filed by the defendant. Defendant number 128, not all the defendant. The problem lies is that the next date was fixed for show cause of defendant number 128 on 4/8. But the problem lies over here is that the defendant number 125 is threatening me to withdraw the suit. Our writ was filed before the Honorable Justice Tirthankar Ghosh. Kindly, my lord.
Police in action.
For police in action. And the state has given the report that the report submitted by the state reflects that a complaint was lodged against them and they are threatening the petitioners plaintiffs to withdraw the suit.
You have got an order in the police in action determination.
Yes. Unless
you are protected by that order.
No, my lord, they are still threatening us to withdraw the suit. That's why I am filing this expeditious disposal.
No, you have got an order, you have lodged a complaint, the writ court has
Yes,
passed a direction
first,
in your-
yes.
So if there is non-compliance of that order, take steps.
And so
Take steps. This application under Article 227 of the Constitution of India is at the instance of the Yes.
For the petitioner. A suit for recovery of possession was initiated by the opposite party in the learned court below. And that suit was decreed ex parte. Coming to know of the
yes,
and an execution proceeding was initiated. When the bailiff came to take possession of the suit property, the applicant herein filed an application under Order 9, Rule 13, which was allowed, and a stay of the proceeding, a stay of the further proceeding of title execution case was kept pending. They came before the Honorable High Court at Calcutta, where this Honorable Court put certain conditions upon this applicant to pay
Yes, what is this misc for?
two miscases are there. One miscase is
35 of 2021.
is opposite parties execution case.
Execution case
arises
is
out
title
of
execution case number. Why it is registered as this case?
For police help, they made another
For police help,
application.
yes.
Yes.
What is the order impugned?
Order impugned is the cross-examination of prosecution witness in, that is the court belief, was going on. This applicant didn't take steps as we.
So 27th of June 2025 application was allowed.
Yes.
What is the application for?
Application was, the opposite party made an application to recall the order by which the learned court bureau has rejected the prayer of recall of the prosecution witness.
So you are agreed by that?
I want that, though both the proceedings are.
No, you are agreed by the order of recalling.
Yes, sir.
Why?
Because my chance of cross-examination has been restricted. They will
By which order?
By the previous order.
So previous order, have you challenged that? You have not challenged that.
No, by then in this, I have challenged this order because I have.
So previous order, by that it was closed, but you have not challenged that. By this order, their prayer for recalling has been rejected. So since your application was rejected, can it be a ground for rejection of this?
I don't want their rejection.
Yes.
I simply want that witness should also be given chance of cross-examination.
That order you have not challenged. You have not challenged that order. How can that be granted? This application under Article 227 of the Constitution of India. matter?
Item number 24.
Yes.
Mr. Bhattacharya, sir. Mr. Bhattacharya, sir.
Since I'm not inclined to take up this matter on call.
Yes, my lord. My lord, I am for the caveator and I have also instruction to appear for the opposite party. I have already filed my.
Who is for the petitioner? You are for the
Yes.
petitioner. Yes, sir. Why have you not
Given-
served him a copy?
My lord, give me an opportunity to serve the copy.
What is the order impugned?
Order impugned, my lord. Order number 139, misc case number 169 of 2023 under section 47 of Civil Procedure Code.
So is it section 47 or order 21 rule 101?
Section 47, read with order 21 rule 101, CPC filed by the petitioner is dismissed on contest without any cost.
No, have you
Being
sought?
maintainable.
Where is the application? Where is your application?
My lord. My lord, I made page number 2 in our page. My lord, this is my application. My lord, I may be given an opportunity to serve the copy of my friend.
Sir, page 62 is your prayer. This is in effect an application under order 21 rule 101. Though you have styled it as section 47. If it is order 21 rule 101, it's a dim degree. Appeal lies. Please prefer an appeal. I'm giving you liberty to prefer an appeal. By the order impugned.
26.
Your Lordship, at the outset, this revisional application is not maintainable because he is challenging the final order passed by the DRT in section 70. Appeal lies under section 80.
Good day, sir. Sir, we have come here. If you see the order of the DRT, sir, it has been without any application of mind. He has mentioned things which we have never said in written or verbally. What we have said in writing and verbally, he has not even included in his final judgment.
Kohli, and there is a provision of appeal under section 18.
Sir, that is due to DRT. That's we will go to DRT, but we are requesting you to ask him to correct these anomalies.
Please prefer an appeal. There it will be corrected.
Sir, DRT, I have to deposit 50% of the demanded amount.
That's the law.
No, sir, the law is that revision. In the revision, I can have a hearing in the revision, sir. Please hear my points. He has made.
There is a repeatedly, when there is an alternative efficacious remedy of appeal, you have to approach there, because repeatedly the Honorable Supreme Court is saying that you cannot bypass a statutory remedy wherein the pre-deposit has been specified under the statute. In order to bypass that, that is not permissible, sir.
Sir, but if he has given an order which is saying the wrong thing, which I've never said.
That, sir, for that an appeal lies.
Sir, but the revision appeal also lies in your court, sir.
227, the Supreme Court is saying no. That's the recent decision.
So, if you see, if we are getting a bad judgment, where I have to pay 90-80 lakhs, I don't have money, sir. I don't even have money to.
Mr. Kohli, that's the law. I cannot bypass that.
Sir, then what is this, your civil revision court for, sir?
Civil division, sir, civil division court is not for that. When this statutory remedy is there, you have to approach that authority. That's the law.
Sir, but what I'm saying is he's given things which I've never said. You just read his order, sir. Give me one hearing at least to see his order. Sir, I'll give you one thing you just kindly you do. You will understand what point I'm making. I have, if you come to M, page number, volume 3, page number 412. Just see this, sir. He has himself recorded in writing my submission, page 412.
412?
Yes, volume 3, sir.
412, yes.
Yes, sir. See, he has recorded account of applicant
classified. So you are challenging the order dated 1st of October 2024.
No. What I am saying, sir, he has recorded this in the hearing, and in his final order, he has not even mentioned it. Just see what he's doing. And sir, in earlier page in the order, he is telling me that I've said this when I've never said it. And he says, I've given in writing. There's no document to support it. So this is being most unfair to a small businessman like me.
Mr. Kohli, is it that matter which we heard in the division bench?
Correct, sir.
Would it be proper on my part to take up this?
Yes, because you're a fair man. I don't have any problem with you.
I think it's.
So please hear it, sir.
I'm releasing it. Please try your luck, because I've decided that before the division in the division bench. Since.
So what do you So then what do I have to do? I'll approach the Chief Justice?
That yes.
Huh?
You can approach the OSD of the Honorable Chief Justice.
Okay.
Because since I've dealt with, because those matters might be something we'll be playing in that.
Sir, but I have full confidence in you, sir. If you
I've not recorded your submission. That is why it struck my mind. That is why I thought it's a different matter.
Sir,
that is why I asked you whether it's the
correct,
same
correct,
matter
sir.
or not.
Sir, just see what has happened. These people robbed my money, State Bank of India, from my customer Kerala Police to complete the 80% complete project, get 7.5 crores. That project is collapsed. The project is collapsed.
I still recollect those facts.
So it's gone to Justice Amrita Sinha's court. They've taken me to case to return the 7.5 crores. Can you imagine, sir? I have completed the project. Almost 8-10 crores. I'm down. I've taken borrowed money left and center for the market, 2-3% per month. Sir, where I've got nowhere to go.
Thank you, Mr. Guru. Yes, call the next matter. Who is appearing? On the prayer made on behalf of Mr. Yes.
Your Lordship, I'm for the petitioner, and this is an expeditious disposal matter. Your Lordship, the appeal is pending before DRT 3. It's pending for from 2023, and till now, I am out of my home, and with my child, I have nowhere to stay. And the DRT is not taking this matter.
What is the next date fixed?
8th January 2026, Your Lordship.
8th of January 2020. By which order?
Last order. This is not mentioned in the order, Your Lordship. The last order is in page number 63, Your Lordship.
What is the challenge in the proceeding before the DRT? What have you challenged in the DRT?
It's the DM order we have challenged, Your Lordship.
Section 14 order.
14 order, Your Lordship.
This application under Article 227 of the Constitution of
Hearing of the matrimonial suit of 2016.
Where are you?
I was the husband petition.
Any alimony proceedings?
No, I have written in the paragraph 4. I have paying 70,000 per month, and stage is that the PWD evidence is.
Which paragraph you have stated?
Paragraph 4, I have stated I have paying 27,000 per month, and paragraph 3, the stage of the suit. plaintiff.
Cross-examination of
Only PW2 has start. I think 1 day is required for it. And another thing, paragraph 5.
Defendant in the suit.
I am the plaintiff in the suit. Divorce filed
plaintiff in
by
the
the
suit.
husband. Yes. Lordship,
The
paragraph.
PW2 is the wife's witness.
Yes, yes. Wife witnesses close, only mother-in-law's witness start. Start and only 1 day close. Lordship, paragraph 5. I am the teacher of this Assam school. Lordship, paragraph 5.
Yes.
And page 4, line 6. From the school to Rangapada, 15 kilometers, then Rangapada to Raigia station.
What do you want?
Say every day hearing. Every day. Otherwise, I am coming from that, attending. Keep the day by day. Otherwise, it is very difficult. From 2016.
How it's very difficult.
No, they have only, I have written. They have already given earlier. Lordship, kindly.
I will give you liberty to make that prayer before the learned translator because it's difficult for me.
If some indication, otherwise, if necessary, if
This
in this
application under Article 227 of the Constitution of বলেছি ডিসপোজড অফ যদি দেখে তাহলে আর বলার দরকার
Yes, next.
Yes.
An application for expeditious hearing of a suit, my lord. I am the defendant in a suit for declaration and permanent injunction, my lord. Suit is at the PH state, my lord. Next is the date fixed on 16th of September for PH, my lord, let that on that date, my lord, the
16th of September.
September, my lord, on that date, my lord, let the evidence be started, my lord.
This application under Article 227 of the Constitution of India is at the instance of the dependents
Yes, my lord.
praying for a direction upon the learned Civil Judge, Junior Division, First Court at Kontai District, Purbo Medinipur, to dispose of title suit number 26 of 2018 expeditiously. Mr. Mondo, learned advocate, appearing for the petitioner, submits that 16th of September 2025 has been fixed for peremptory hearing of title suit number 26 of 2018. So, in the light of the submissions made by the learned advocate for the petitioner, CO number in the Tarage, in view of the order sought and proposed to be passed, there is no necessity.
Number 31, on behalf of the petitioner, I have prayed for the adjournment, my lord. I prayed for the adjournment, my lord. Mr. Anisur Rahman, he is appearing on behalf of the petition.
Where is he?
Due to his illness, he could not come before your lordship.
On the prayer, on the
My lord, I am appearing for the petitioner.
Yes.
My lord, in this the matter arises out of a preemption case.
Yes.
And in this matter, my application praying for handwriting expert was rejected.
Handwriting expert for what?
My lord, for comparing the handwriting of the petitioner number 1 in the preemption case with a deed that I produced, because the petitioner claimed the preemptee petitioner here claimed that the petitioner number 1 over there has time and again assured the OPs that she has not filed any preemption case, and the signatures were disputed.
Who disputed the signature?
We have, my lord. My application is at page 22, my lord.
Who are you in the preemption application?
I am the OP. Sole
Yes.
OP. Sole OP, my lord.
Yes.
I have prayed for handwriting expert of comparing the handwriting in the preemption case petition of the petitioner number 1 with another standard signature of the petitioner number 1 in the preemption case. She has executed some deeds. I produced that. I have stated that in my application at page 23, my lord. The learned judge compared the signature himself and passed the order.
Nothing.
Learned judge did not consider section 45 of the Evidence Act or section 39 of the BA.
73 is also there.
Well,
Section
73 is there, but my lord,
Nothing.
my
Please
submission,
contest the suit on merits, nothing.
my lord, I can contest. My lord, kindly sees
Yes.
that there is some this petitioner number 1 has gone to the house of, they are relatives. They have gone to the house of the OP and stated time and again that I have not filed any case. So that is where my suspicion arose, my lord. And thereafter,
But they are not saying it's not their
my
signature.
lord, they are not saying, but we have not admitted.
Maybe.
My lord, I am relying on this.
Yes. Yes.
Well, this is one of the execution case, my lord. The matter went up to the Honorable Supreme Court.
Yes. What is the impugned order, Mr.
My lord,
Mukherjee?
this is, my lord, for disposal of the execution case.
For disposal of the execution
My
case.
lord, if your lordship kindly turn to the order dated 24th August 2022, order number 75. Already matter was ready for payment. If your lordship kindly read order number 75. One of the ordering portion. The payment order.
No, you have challenged the orders.
So I have not challenged. I said, my lord, to get the execution case, I am, my lord, due. This is a land acquisition case.
So you want this execution case to be disposed of within a time.
Stop, my lord, in terms of the at least Supreme Court order whereby, my lord, the
I am directing the execution case to be disposed of. Execution case number 1 of 2010.
Yes. My lord, about 8 crores, my lord, if the Supreme
So
Court
though
within 6 months, the Supreme Court I'm grateful.
Show me your application.
My lord, kindly take up page 22. Annexure C, my lord.
Where is the objection?
My lord, page 24. Just the next document.
Yes. Evidence Act দিন তো Evidence Act.
Lord, Malan may take my copy.
Yes. Yes.
My lord, I was referring to a judgment.
79 Supreme Court.
Yes,
Which
my lord.
paragraph you are referring?
Paragraph 29, my lord. Kindly takes up. May I place, my lord?
Yes.
The matter can be viewed from another angle also. Although there is no legal bar to the judge using his own eyes to compare the disputed writing with the admitted writing, even without the aid of the evidence of any handwriting expert, the judge should, as a matter of prudence and caution, hesitate to base his finding with regard to the identity of a handwriting, which forms the sheet anchor of the prosecution case against a person accused of an offense, solely on comparison made by himself. It is therefore not advisable that a judge should take upon himself the task of comparing the admitted writing with the disputed one to find out whether the two agree with each other. And the prudent course is to obtain the opinion and assistance of an expert. The paragraph 30, it is not the province of the expert to act as a judge or jury, as rightly pointed out in Titley versus Jones, ILR 56, all 428 and AIR 1934, Allahabad 273. The real function of the experts to put before the court all the materials together with reasons which induce him to come to the conclusion, so that the court, although not an expert, may form its own judgment by its own observation of those materials. Ordinarily, it is not proper for the court to ask the expert to give his findings upon any of the issues, whether of law or fact, because strictly speaking, such issues are for the court or jury to determine. The handwriting expert's function is to opine after a scientific comparison of the disputed writing with the proved or admitted writing with regard to the points of similarly and dissimilarity in the two sets of writings. The court should, Malak kindly takes note, the court should then compare the handwritings with its own eyes for a proper assessment of the value of the total evidence. The application of section 73 as per the judgment comes only after expert opinion is there to assess the learned court below. In paragraph 33, the Honorable Court then directed for handwriting expert. In gist, I'm also relying on another judgment of a coordinate bench. This is 2016 volume 3 Calcutta Law Journal 382. The paragraph 23 is I'm relying on. May I please, my lord?
Paragraph 23.
Paragraph 23, the last page, my lord. I find that in the written statement at para 2C, page 6, the petitioner stated that the first part, which resembles by the petitioner's handwriting, is not his signature. That does not mean that the defendant petitioner admitted his signature, though it is evident from the record that every time petitioner disputed the signature as well as the contents. Therefore, it was the duty of the learned court below to appoint a handwriting expert to examine the disputed signature of the petitioner. It is admitted that the court has power to compare, but it is safe if it is sent to the expert because court should not usurp of an expert. Considering the above discussion, I am of the view that the impugned decision dated 16th April 2015, passed by the learned judge, 10th Bench City Civil Court, Calcutta, in money suit number 609 of 2009 cannot be sustained. Therefore, order number 41 dated 16th April 2015 passed in money suit number 609 of 2009 by the learned judge, 10th Bench City Civil Court, Calcutta, thereby rejecting the objection under order 26 rule 10A subsection 1 read with section 151 of the Code of Civil Procedure is hereby quashed and set aside. Paragraph 25, I direct the learned judge to revisit the said application under order 26 rule 10A1 of the Civil Procedure Code for appointment of handwriting expert in accordance with law, after giving an opportunity of hearing to the parties, and dispose the same within 10 days from the date of communication of this order till the disposal of the said application by the learned judge. No final order shall be passed in the said money suit number so and so.
The application under Article 227. Ashun.
it arises out of the same order. Different proceeding, but same order. The same order was passed in 3 proceedings, my lord. At the
3 preemption case.
3 preemption cases, my lord. Same parties. No, the OP is different only. So the petitioner is different.
Oh, so here you have challenged the, no,
Same order.
petitioner is the different. Only the
Petitioner before my
is
lord.
the different.
Preemptive is
Preempters are same.
Preempters are same.
Same order, eh? শুধু ওই এটগুলো চেঞ্জ হবে প্রিএমশন কেস নাম্বার অর্ডারের ডেট ওইগুলো শুধু
Case number and party, the petitioner is different.
yes
Grateful.
there are 3 the other one you have not challenged
No, my lord, I have filed. There was some defect. It is filed today. It will come up later on.
thank you yes
Grateful, ma'am.
next
35. My lord, I am appearing on behalf of the petitioner, my lord, led by Mr. Anand Banerjee, my lord.
yes
I am for the
Yes.
opposite party.
This is my affidavit of service, my lord. There is a caveat. We have
yes
this matter, my lord. I have challenged the order of the arbitrator, my lord. 2 ground. One is that the amendment application is allowed without considering, without recording our submission, my lord. We have made the elaborate submission in this matter. In the minutes, it was mentioned, but in the order sheet, it has not
even if
been.
your submission is considered amendment has to be allowed so I will record your submission here and
My lord, and the second point is that the mandate of the arbitrator has already been expired. After expiry, my lord,
that amendment was allowed
yes, my lord, that is our contention is that, my lord, because the
say with regard to that
My lord, they have still not filed their sub rejoinder. We have filed an
no, but
application.
if the mandate has expired
Mandate has not expired because the mandate starts upon completion of the pleadings.
yes
In the 14th minutes, it was recorded they wish to file a sub rejoinder to our statement of defense to the counterclaim. We had filed a statement of claim. They had given a statement of defense counterclaim. We had filed our rejoinder come statement of defense to the counterclaim. They prayed for time to file sub rejoinder to that. Then it
where is the scope of filing a rejoinder to that
they have, my lord, that leave has been granted. They have prayed for it. That leave has been granted.
application, I think.
no, আমি post করেছি
so your junior has made submissions all right you can make your submission.
Kindly allow me, my lord, to, because there's some points, my lord. Now, this is arising out of an order of the learned arbitrator allowing 2 applications under section 23(3) for amendment.
Banerjee, your junior has placed it very nicely.
She is hardworking, my lord. She is very hardworking. 2 applications for amendment
2 applications for amendment
were allowed. Taken up, my lord, both heard simultaneously, then both have been allowed.
that your instance
No, filed by the claimant, my learned friend.
yes
Now, let the matter is arising out of not a contract between the parties. It is not a booking principal e-ticket booking agent contract. He is the principal e-ticket booking agent for SBSTC. The scheme is like this, my lord. He will pay some money to our account, that is recharge amount. Suppose rupees 100 is paid. He gets tickets for rupees 100. He sells the tickets to the commuters and he gets a commission on the amount of tickets sold. This is the system. Now, we found that there is excess sale of tickets. Suppose he pays 100, we give him 100. There is sale of 110.
how can it be
It is done, that is the dispute. We say, my lord, that there is a computerized system, my lord. Somehow, my lord, he has hacked the system through somebody and excess tickets are sold because the net balance now comes to negative. We found that the opening balance comes to minus 7.19 crores. So
7.19 crores
so excess tickets were sold. So we found that. We not immediately the
so Banerjee, you are closing down your bus service so
this is the dispute. I am not onto the dispute today, my lord, because the learned arbitrator was considering it. Now, what happened, my lord? So we filed we gave a notice to him, which is under challenge on 30th of December 2021, that we have found this excess amount has been disbursed by you or sold by you. So we shall deduct 20% of the amount which you recharge. If you recharge rupees 100, we shall give you tickets of rupees 80. This notice was challenged initially section 9 before the commercial court. He got a stay that on the first day you cannot issue this notice. Then the notice was challenged by him by way of filing the High Court appointed arbitrator. Proceeding commenced. So the dispute is regarding the notice of the MD, which is at page 61.
Yes.
Page 61. This is the dispute.
Yes.
During
Page
pendency
61.
61. This is the
Yes, now what is the impugned order?
Impugned order I'm placing, my lord. I'm just giving the background because some background fact is required. During pendency of the proceeding, my lord, FIR was lodged. And several reports from the government also came from the, my lord, finance department, audits were done. Those reports also confirm that yes, there has been excess sale of tickets by the agent. FIR was lodged. After that, invoking a certain clause of the agreement, we terminated his service. It's a letter of termination. So his amendment is vis-a-vis the letter of termination challenging the termination.
Whose amendment? His amendment.
His first amendment. Two amendments filed. First
Yes.
is my lord challenging the notice of the MD. Second is he wants to incorporate the termination letter issued to him by way of amendment to the proceeding. And subsequently, my lord, some counters were set up by SBSTC in the premises which is owned by SBSTC. He said that we cannot do that because he has the exclusive right to sell. So we cannot have parallel counters. Although everything is within our premises. So after setting up, that is the, my lord, second amendment application. On merit, our objection is that since it is, my lord, under the Arbitration and Conciliation Act, you have to, if there's a particular dispute, you have to invoke the dispute and go to arbitration. Their answer to that is that 23.3 says that claims can be added. That is on merits. I'll go to that later. Amendments were filed. Now, my lord, the order which is being challenged by us, first ground, there are two technical grounds and on merits. Technical grounds are, my lord, first is that if your lordship sees the impugned order now, my lord,
you are challenging those amendments.
Those amendment orders. Orders allowing, my lord, amendment and incorporation of the, my lord, subsequent events in the, my lord, anvil of the running dispute. This order is, my lord, at the end of, my lord, the revisional application, volume 2.
Order dated
19 June 2025.
Yes, yes.
My first ground is, my lord, that although elaborate submissions were made by me, which is recorded at pages 251 and 253, your lordship will find my entire argument has been recorded in the minutes. Every day minutes were, my lord, issued. Now, when the order is passed, there is no reflection of my argument and no application of mine to my argument. Only Mr. Das's submissions are recorded. I find it is justified. Kindly see, my lord, where is the, my lord, application of mine in the order? Only, my lord, paragraph 4, one line is there. Paragraph 4, one line, the main objection of the respondent with regard to the amendment is that fresh cause of action has arisen for which claimant has to issue fresh notice for arbitration. Only one line. Then he goes on with the judgment cited by Mr. Das. He accepts the, my lord, contention of the raised by way of those citations. Goes on. Paragraph 7 up to 8. All Mr. Das's submission. Then paragraph 9. Paragraph 9, the lordship has come to paragraph 9. Respondent has not cited any judgment. That's all. On a consideration of the cases.
You had cited any decision?
I had not cited any decision, but an elaborate submission was made. I distinguished the judgments. Everything is recorded in the 2 minutes. Now, on a consideration of the cases cited on behalf of the claimant, I uphold that the claimant is entitled to amend the statement of claim only confining to the subsequent events and not otherwise. That's the, my lord, only thing. So, no consideration of my, my lord, submissions, the points raised by me, nothing is considered. This order cannot stand, my lord. Recording submission of one party and coming to a conclusion cannot be done. She allows. Now, my lord. Oh, and in 45th minutes, when the hearing was going on, he already has made up his mind. To page 254, kindly page 254. He records in the event amendment is allowed, what course of action shall be taken. So before passing the order, he had made up his mind. 254 kindly comes to third paragraph. Mr. Das concludes his argument. In the event the amendment is allowed, in that event the claimant will furnish the respondent with the statement of claim by 30th June. Amended paragraph should be underlined with reading. So he's already, before passing the order, he has already made up his mind. He will
yes, Mr. Das.
And my submissions not reflected anywhere. This is one more point. Every minute.
Each of his judgments cited are all recorded in the minutes. He has made his
But at the time of passing an order, is it not required that those are to be considered? If it is in the minutes, then
He has two
And
grounds, my lord.
by this
Second
order,
ground
the
is not
earlier
taken
order, in the minutes, it appears that the learned arbitrator had made up its mind.
because my, the hearing was concluded. He said, I'll pass the detailed order later. In the event I pass in favor of amendment, then these things will be carried. No, but this is a practice where, my lord, judgment
So,
is
this
reserved.
is-
My lord, kindly seize that order because hearing is concluded. Here,
Judgment is, yes, when the judgment is reserved, these orders will be passed. If it is passed, that will be done.
in the interest of but that observation can be taken because the order is, my lord, detailed. His objection is that this is a fresh cause of action. That has been taken into account. Here, the elaborate.
Where are your objections, Mr. Banerjee?
Kindly comes to page 251 first, my lord. 251, my lord, it is entirely my submission. 251 and 253, that is also my submission. 253 up to, my lord, the first, second, third paragraph.
Yes, elaborate submissions. Where is the finding on this?
Audit, my lord, the submission was that you have to give a fresh section 21 because of fresh cause of action.
No, the several factual submissions were made.
No
So that we
deflection.
dealt with. Nothing has been dealt with.
But
show me that it's only one line that it's a fresh cause of action has arisen.
Only
Which
one
the
line.
claimant has to issue fresh notice for arbitration.
But
Nothing
kindly
is than
see
that.
para 4. The main objection of the impugned order is at page, my lord, in the impugned order, para 4.
Yes.
Main objection of the respondent with regard to the amendment application is that a fresh cause of action has arisen for which the claimant has to issue fresh notice for arbitration.
Yes.
Entire objection is an elaboration of this. A short recording of submission is not, my lord, then it is a respondent, the argument.
And what
has
is
been-
your submission?
My lord, I had countered with a judgment. The Supreme Court has said
Yes.
2012. But I had countered with this judgment of Praveen and State of Goa versus Praveen Enterprises. He has dealt with that judgment that even after section 21 at the stage of statement of claim, new claim can be added. That is the import of section 23 subsection 3. But kindly see, the argument has been countered by the claimant and in support of his submissions, the claimant's advocate has relied upon the decision reported in 2012 SCC 581. According to the claimant, the subsequent actions taken by the respondent form one cause of action and for this no fresh arbitration proceeding is required. The subsequent events for a continuous chain of events on the basis of which the original statement of claim was filed. This is the admitted position. They say that there is some negative balance. The claimant also relied upon the judgments reported in these.
Show me the application for amendment.
Yes.
Page 143 and 193.
And where is the original application, claim petition?
Statement of claim is page 25, my lord. Prayer is at page 61. But there is one more point made.
Just one. Their main issue and their counterclaim. They have made a counterclaim of 7 crore 19 lakhs. Their claim is that I have defalcated some amount from the system. On that basis, there was a first notice saying that I will deduct money from you on this basis. Then that notice itself says I will communicate.
I should complete. He cannot comprehensively reply because I have not taken all the points. I have taken only one point.
Yes, by this honorable court, I am.
May I then complete my submission?
Let him complete his submission.
He can deal with comprehensively. So first point is, my lord, that non-application of, my lord, non-consideration of my submissions. Only one line which does not, my lord, take care of the specific submissions raised by me. This is first point. I have shown your lordship the 2 minutes, but he has not considered that. The second point is, my lord. Also, second point is, my lord, although, my lord, parties participated, I find that, my lord, the direction for filing of statement of claim, statement of defense and sari joinder. Now, there one judgment of Karnataka High Court which says that surrender shall also be considered. I fail to understand how, because statement of claim, statement of defense, and there might be, if there's a counterclaim, then there might be a rejoinder, because counterclaim is a separate suit, so WS. Up to rejoinder is not, I understand, but surrender is not replication. So there's a judgment of Karnataka High Court which says that even replication, if it is filed and taken on record, that would be completion of pleading. This judgment is there. One judgment. In this case, direction for filing surrender was given by 30th of September 2023. Surrender never filed. So even if we assume, although I personally feel that surrender cannot be pleading. It cannot be. But even if not, it is treated to be pleading, my lord. The time to file surrender expired on 30th of September 23. Nothing filed. If that is not filed, then this judgment will not come to their aid. Because
mandate expired.
Mandate expired. In my calculation, if that 6 months, that is not, even if it is treated to be directory, because there is one coordinate bench judgment, Jashovardhan coordinate bench judgment, which says that it is directory. Jashovardhan Sinha HUF, which says it is a directory. Now, even if it is directory, my lord, this period expires on the time when the time to file surrender expires on 30th September 23.
Yes.
Then 12 months. So September 24, my lord, in any case, it expires. Because non-filing of surrender, they cannot say that so long you don't file, it will continue for eternity. That cannot be. So, but in the last day, my lord, we did not attend the sitting. We said that it has expired.
Arbitration constellation.
We said that it has expired. The tribunal has said now the statement of claim has been amended. So it's fresh pleading. So it will continue. But my submission is that the day when the application was considered, my lord, on that date, he didn't have the mandate. So the order is challenged on that ground also by me. The minutes were there. These are the minutes of the 14th sitting.
So this requires to be heard.
Request to be heard, my lord.
These are the points.
Let the tribunal not proceed with the hearing, because I have taken the point of not
to be stayed.
Kindly consider the scope of interference at this stage.
Yes, but the question is if the mandate has lapsed. So
I'll satisfy your lordship. It has not left.
I will hear it. I will hear both of you.
And third point is on
coordinate bench judgment that rejoined not only Karnataka High Court, our High Court has held
Completion of pleadings under section 23(4).
23.
What does section 23(4) say? The statement of claim and the defense shall be completed within a period of, so statement of claim and defense. So even if it is considered that counter claim, then the defense to the counter claim, nothing more than that.
Argument have taken before a coordinate bench. The coordinate bench has held that rejoinder, sub-rejoinder, where parties have agreed it will be filed, will be part of the pleadings under.
Even then it has expired. Even then,
that
the
is not
time.
because my kindly see section 25. If
Yes.
someone does not file within that period,
Yes.
his opportunity to file has to be closed. Then it expires. I have made an application for closing his opportunity. That is not yet, my lord, pending before.
All right,
the
so these issues are to be considered. Ashun, by the Yes.
After filing, my lord, we got the caveat, we have served.
You have served.
Yes, I have served.
Where is the caveator?
Nobody is appearing.
Yes, what is the order impugned?
My lord, application under order 1 rule 10(2) filed by the third parties allowed in a suit for eviction against the tenant.
Who is the third party?
Third party, they are claiming to be the brothers and sisters, the son and daughter of the original tenant. I have filed the suit against Asim Datta and
Wife of Asim Datta.
wife of Asim Datta. He was the recorded tenant. He died, wife made party, and suit has been proceeded. Now,
Where
they
is
are-
the application? Where is the application?
Yes, my lord, kindly come to page 31.
और हमें ऑब्जेक्शन দেওয়া হয়েছে সাইটেশন পর্যন্ত সেটা কোর্ট কনসিডার করেনি
Actually, they are the subtenant, according to me.
Sir, it's better. Otherwise, in the execution, they will
I
come.
know they can come under order 2097,
So,
but
why are you taking that risk? So it's once
but
for all.
by notice point, everything will be against me. Let them come at the latter stage. I'm running with the risks. I have understood as it falls from your lordship. But in a suit for recovery of possession against the tenant, the relationship of landlord and tenant as it appears.
I appreciate that.
I
But
do agree.
Mr. Rai, this is a suit of 2025. Please consider this. You will proceed. Now at the execution stage, everything will go.
I know that, my lord,
So you
that
can,
things have run.
nothing prevents you from,
But
it's
my lord,
only a fresh suit.
there will be some other difficulties on my part. If they are added, the moment they will be added, it will be converted.
It's a question of addition. I cannot say.
I have understood, but my lord, it is the instruction of my client, my lord, that they cannot know. But let them file separate proceedings. I have
Yes, next.
Party number 37.
The PMT is the petitioner before your lordship.
What is the impugned order? What is the impugned order?
By virtue of my lord, learned trial judge was pleased to hold that the preemption is not maintainable since the entire suit property has been transferred. But the learned appellate court held the preemption is maintainable but has not come to the conclusion regarding satisfaction of any of the grounds in the preemption case. So far as the maintainability of the preemption case is concerned, learned trial judge held preemption is not maintainable. Appellate court held preemption is maintainable but has not come to the conclusion regarding satisfaction of any of the grounds.
Show me that.
Can you have a look at my lord, page 13 of the impugned order. Paragraph 17, the law as enunciated certainly by the successive decisions of the Honorable Court makes it ample clear that there is no bar to claim preemption over the transferred portion of the plot in favor of the preemptee by the transferor, notwithstanding the fact that the entire share of the transferor has been divested in favor of the preemptee, and thereby the transferor has become a non-co-sharer right of a plot of land which is the subject matter of the case. In the instant case, it is admitted position that Naju will be transferred her entire share in the subject plot in favor of the respondent opposite party. The language so employed in the statute has manifestly adumbrated that there is no distinction between a share of the plot of land or the entire share of the subject plot. If other requirement is satisfied under the provision of Section 8 of the West Bengal Land Reforms Act, the claim of preemption cannot be denied or defeated due to the fact that the entire share of the vendor in the subject plot has been transferred to the vendee by the impugned registered deed, which is the subject matter of this. Nevertheless, the right of preemption is a weak right. The object of the legislator is to consolidate the land holdings of the existing co-sharer of the plot of land to avoid fragmentation of the land as well as to maintain continuity of the nature and character of the land in question. Moreover, the preemptory right is also enabling the co-sharer right to exercise his or her option to purchase a share or whole of the share of another co-sharer in the subject plot with a view to perpetually acquire the said share for the purpose of better management and use of the property in question and to avoid the incoherent or inconsistent use of land by the stranger purchaser in comparison to the existing co-sharer preemptor. In this context, at the cost of reiterating the factual matrix of the case, I cannot but to negate the submission of the learned advocate for the opposite party respondent that Najububi had transferred the entire share of her in as much as even if the transferor has divested.
That is the order of the trial judge.
This is the first annexure A, page 10 onwards.
This is the application for preemption on the ground of adjoining owner.
On the ground of co-sharership and vicinage.
Yes, also on the ground of adjoining owner.
My lord.
So, are you disputing that you are the adjoining owner? He is the adjoining owner?
But the court has not come to any conclusion.
Where? Show me your deed.
No, my lord, so far as the ground of co-sharership, so far as the adjoining landowner is concerned, so far as the maintainability point is concerned, court has only decided that. Appellate court has also decided that appeal is maintainable, preemption is maintainable.
The entire evidence was laid.
That's true, but court has not, but the appellate court has not come to any conclusion that the preemptor is entitled to preempt the land on the ground of any co-sharership or any on the ground of
the finding of the learned trial judge with regard to the co-sharership or vicinage, any finding?
No finding, my lord. Court has said, my lord, that since the entire share has been transferred, preemption is not maintainable. Learned trial judge held. The learned appellate court will, my lord, ought to have come to the conclusion on any of the grounds that the preemption is maintainable. Preemption is to be granted. Both the courts will held, my lord, only on the ground of maintainability of the preemption case.
No, but here the it has been held kindly come to the appellate court's judgment, page 7. Paragraph B. Opposite party has purchased the entire 8.2 decimals on the western side of the suit plot. Petition of the petitioner reflects that the petition is on the eastern side of the suit plot and Najma Bibi possessed on the western side. Petitioner has admitted the partition and the petitioner possesses on the eastern side. She herself admitted that had sold such and such. It is the admitted fact has sold her entire with specific such no relief is maintainable. Has not the petitioner has finally also being the adjacent boundary man does not prove this fact by way of giving any evidence.
Court has not come to any conclusion. This is just only
And what do you say with regard to the entire share?
so far as, my lord, the entire share is concerned, my lord, the preemption is not maintainable. That is the reason why, my lord, the matter has been referred to the larger bench. That is another chapter, my lord. But so far as the conclusion, so far as the instant case is concerned, because the court has not come to any conclusion.
Larger bench has nothing to do.
But another coordinate bench case, another coordinate bench held that, my lord, the so far as the Chanadani's case is concerned, my lord, nothing has been decided.
Supreme Court is there, considering Supreme Court division bench is there. It's binding upon me. That's binding upon me.
But if you set as that portion, my lord, but so far as the instant case is concerned, but the learned appellate court has not come to any conclusion. So far as the ground of preemption is concerned.
There is substance.
But otherwise, my lord, I will not be protected, my lord, for the time being, my lord. Kindly consider this.
You have sufficient power to protect your possession. Till now, you have protected your possession. You can
kindly consider for the time being, my lord.
File an application, nothing.
I beg to appear for the petitioner, my lord. Order 9 Rule 13, I was directed to put in certain cost in terms of Order 9 Rule 13. But I did not put in the cost ex-parte decree for divorce. My lord, I did not put in the cost. Thereafter, I take out an 151 application.
But the husband, rightly.
My lord, suit for divorce, my lord, decreed ex-parte, my lord, this is judgment in rem.
Do you, Mr. Banerjee, do you think that they can live together? I'm asking it to you, this question to you. If you say yes, yes, I will interfere. Otherwise,
My lord,
Look,
suit for
Banerjee-
divorce, my lord, ex-parte decree was passed.
I appreciate that, Mr. Banerjee. I'm very liberal in that. But considering the nature, and that is why I'm asking you, do you think your clients says that they can live together?
But, that we do not have any instructions, my lord. I have not interacted with the client, my lord. I have not personal interaction with the client, my lord. Now, what has happened, my lord, under 151 or 2,000 rupees cost, my lord, I was directed to put in within a certain date. I did not.
This shows the ego of your client, Mr. Banerjee.
So
That's
thereafter,
the
my
ego
lord,
for which rightly it was rejected.
no, thereafter, my lord, on that event day, I say that I seek time. My lord would kindly takes order number 14 once. Order number 14, my lord, I seek time. Learned advocate for the petitioner had filed the
Banerjee,
petition.
any purpose will be served.
But, matrimonial suit, my lord, suit
What
for
will happen?
divorce.
Yes.
Or he
When
will not
both of them live
contest.
together, I'm appointing you as the mediator.
My lord will not entrust that.
All right, I am appointing Mr. Mundal as the mediator.
Yes. Mediator. দুজনকে একসঙ্গে থাকতে হবে হাজবেন্ড ওয়াইফ কে
Both
একসঙ্গে
the
থাকতে
parties are fighting.
kindly send it to mediation, my lord, or my lord.
Without the consent, I cannot.
My lord, may I at least serve and come back, my lord? May I serve and come back. My lord, let's see, my lord. Though I have not
Your client
interacted,
eager to stay with the wife, Mr. Banerjee.
or I have not
He does not want to pay 2,000 as cost. That is the
But
ego.
it's not that he does not want. On that event day, he sought for a time, my lord. That's the order, my lord.
That is the ego. I will not pay.
Not that, my lord. Otherwise, why would he have said so, my lord? But kindly consider, my lord.
I'm for the petitioner.
So I'm the caveator. I'm led by Mr. Choyan Gupta. He's appearing online.
Yes. Where is Mr. Gupta?
Yes, my lord.
Yes.
But
Mr. Gupta, you have stopped appearing physically.
No, my lord, I had to come to Bombay for a personal reason, my lord, for an emergency, my lord, the medical emergency at home.
Yes.
Lordship, this matter, I am aggrieved by an order whereby my evidence has been closed. The witness I opted to.
Why your evidence has been closed?
Lordship, I had opted for a passover during the matter. The witness is an advocate witness. He was
Mr. Gupta.
I do not stand in the way, my lord. Let on the next date, my lord, they produce evidence.
August.
But I do not stand.
Your evidence was closed.
Yes. I'm the
So, chief, you have tendered chief, no?
Yes, I have everything.
So it's for
completed.
examination.
Yes.
No.
The DW1's examination is complete. I am about to give DW2's examination.
DW2 evidence was closed.
That was closed.
What is the next date fixed in the suit?
19th of August.
19th of August. Mr. Gupta, you want some cost?
No, my lord.
Thank you. Thank you. This application under Article 227 of the Constitution. You sought for a passover.
Yes. And that is also recorded, Lordship, page 27.
Well, this was really for the reason being they have been dragging the matter all along. The order per se that day there was no fault maybe, but they had managed to drag the suit for 15 years. That is possibly one of the reasons which has irked the learned judgment.
Article 227 of the Constitution of India is at the instance of the defendant and is directed against an order being number 85 dated June 12, 2025, passed by the learned judge 5th Bench Civil Court at Calcutta in Money Suit number 723 of 2012. Posted by the order impugned the evidence of the defendant stood closed and a date was fixed for argument. Mr. The learned advocate appearing for the petitioner submits that on the date fixed for evidence of DW2, an adjournment was paid for on the ground that the witness, who is a learned advocate, is engaged in other court. He is engaged in another court. First up, he therefore submits that an opportunity be given to the DW2 to adduce evidence. First up, Mr. Gupta, learned advocate appearing for the opposite party, submits that the that the petitioner herein is dragging the instant suit, which is a suit for recovery of money. First up, he submits that since an adjournment was paid for on frivolous ground, the learned trial judge closed the evidence of the defendant. First up, however, taking note of the fact that the suit is for recovery of money and only a prayer for time was made on the ground that the witness, who is a learned advocate, was engaged in another court. This court is of the considered view that a last opportunity should be granted to the DW2 to adduce evidence. First up, it has been uniformly submitted by the learned advocates for the parties that the next date fixed in the suit is on September 19, 20. On August 19, 2025. First up, in the event, if on August 19, 2025, the DW2 appears to adduce evidence, the learned trial judge shall permit the DW2 to adduce evidence on that date. First up, if however the না কি বললাম তার আগে একটুখানি করে আগে একটা লাইন লিখে দিন ওই যেখানে বললাম না দিস is a suit for recovery of money, and this court feels that an opportunity should be granted to the DW2 to adduce evidence subject to certain terms. First up, in view thereof, the order impugned stands set aside. ঠিক আছে, তারপরে এখানে যেটা বলছি, if however the DW2 does not appear on the next date, that is on August 19, 2025, the learned trial judge shall proceed with the suit in accordance with law, and this order allowing the DW2 to adduce further evidence shall automatically stand recalled. And full stop. In the event the DW2 appears on 19th of August 2025 before the learned trial judge to adduce evidence, the learned trial judge shall make an endeavor to dispose of the suit as expeditiously as possible. This is the last witness.
I'm not instructed, but hopefully this.
Your Lordship.
As expeditiously as possible, but preferably within a period of 3 months from the next date fixed, without granting any unnecessary adjournments to either of the parties.
Grateful.
You are disposed of with observations and directions. Call the next matter.
At 40 minute, I beg to appear on behalf of the petitioner, but I'm sorry, Millard, I'm not there physically.
Yes.
Millard, this is from Millard, an order rejecting by Order 39 Rule 7 application.
Matter Mr. Partho Protimraj is appearing for the opposite party. He is engaged in court.
He's a busy advocate, madam. He will be engaged.
I'm praying for a short pass over, Lordship.
Now, Mr. Banerjee, do you have any difficulty in taking up this matter? It's from Baripur Court.
No, Millard, my lord inquired that, Millard, on the first occasion also. Millard, we don't have any difficulties. It's our privilege, Millard, to address your lordship.
I'm asking you whether I have any difficulty. That is
No, Millard, not to our knowledge. Not at all to our knowledge.
Yes, what is the impugned order?
Millard, the impugned order is rejection of my Order 39 Rule 7 application.
All right. Mr. Banerjee, Mr. Rai is there. All right. Good. Yes, call the fixed matters.
Yes.
Yes.
Milord, the next matter was also of mine, Milord. Can that also be, Milord, fixed then on any other day? 41 was also of mine.
We called on from 40. From 40 on the next date will be called.
Great. So grateful.
So, right, this happens with the busy councils. They come after the next matter is taken up. So busy advocate, they are no fixed matter ডাকুন না অনেক মামলা ওদের জায়গা করে yes which item is this 94
Milord, I appear for the appellant, Milord. I'm praying for not this week, Milord. There is some urgency matter, Milord. There is some bereavement in the family of the advocate on record, Milord. I have already told my learned senior friend also. Not this week, Milord. Let the matter be remain in the fixed position, Milord.
What is the impugned order? What is the impugned order? You are the advocate on record?
No, Milord.
You are also not the advocate on record?
No, Milord.
Yes, Mr. Bundal, what is the impugned order?
To be adduced.
Your prayer for recalling was allowed.
Yes.
Certain documents should be exhibited. That was allowed, and Malord also Malord opposite party Malord to right to cross-examine the same. That I exhibited the same on the same.
Right. When do you want?
Milord, Monday at 3. Milord. Most humbly praying, Milord.
Monday.
Milord.
দেখুন এটা Monday, Mr. Bundal.
As you
Monday. Yes. Next.
Item number 1.
আচ্ছা ওটা order record করে দিন. An accommodation has been paid for on the ground of
Petitioner, Milord.
caveat.
No, Milord. Defendant is the petitioner, Milord.
Yes.
So, my scope is very limited. I know, Milord. That is a rejection of Order 7, Rule 11 application. I filed a. Milord, kindly come to the page 11, Milord. That is the plaint, Milord.
Page
11. 1-1. That is annexure A.
Of the civil revision application?
No, sir. No, Milord. The plaint.
No.
Of the civil revision.
Yes. Page 11 of the civil revision application.
Milord.
Yes.
My lord. Page 12, my lord. Paragraph 2.
Yes.
That the schedule below property belong to the predecessors of the plaintiffs and the defendant number 1 to 4 and the pro forma defendant number 5 to 9. But due to the suit plot is big plot having an area of 45.701 acre, some portion of the suit plot was vested to the state, which is described in Schedule 2 below, and rest portion, which is specifically described in Schedule 3 below, are the owner, possessor, and the title holders of the plaintiff, defendant number 1 to 4, and the pro forma defendant number 5 to 9. And the Schedule 1 below property is the entire plot, and the Schedule 2 below property is vested area, which is in interstate of the state and the forest department, and the Schedule 3 below property is the royalty property of the plaintiff, principal defendant, and pro forma defendant number 5 to 9 respectively, below. Now, below, kindly come to the prayer, below. And below, page 14, below, kindly come to page 14. Page 14, paragraph number 4. Page 14 below, second line below, there was no partition between the plaintiff defendant number 1 to 4 and the pro forma defendant number 5 to 9. Now, my lord, what they had sought at the prayer below, at page 15 below,
Yes.
They prayed for a declaration as to the right of occupancy, below. Now, below, this property, below, is 45 acre, more than 45 acre, in which, below, the state of West Bengal is also a party. If, my lord, come to the plaint, below, they made state as the pro forma defendant, below, instead of the principal defendant. And below, they filed the suit by schedule 1, 2, 3, 4, that itself, though it is an unpartitioned property, but the plaintiff himself partitioned the property on his own by way of schedule and delegated the schedule 2 property to the state of West Bengal.
No. Paragraph 2 says schedule 1 is the entire property.
My lord.
Schedule 2 is the part of schedule 1.
Schedule 1?
Schedule 2 is the vested property. So this
now
and schedule 3 is also a part, that is the Rayati property.
Below.
So according to them, they are not claiming with regard to the vested property.
Yes, below.
They have segregated. It's not partition, it's segregated, it's vested. Partition will be whether there is unity of title and possession. Once it's vested, the parties lose
Now,
title and
my
possession.
respectful
So
submission, below, which
it's not that. No, that's, see, it has been said that out of that, entire is 45.71, vested is 24 acres, and 21 acres is schedule 3.
It is the contention.
21, that's the plaint case.
That is the plaint case.
We have to go by the plaint case.
My lord, that is my
order 7 rule 11, we cannot go to anything else.
If my lord kindly, my lord, though I don't have that document, right to place that document, if my lord come to supplementary affidavit, I have placed, my lord, on the last document.
That can be decided at the time of trial.
Well,
all documents.
One thing.
Sir, I cannot look
lord,
into other
one
documents.
One
Yes.
document, my lord, one document.
Yes,
I-
supplementary affidavit, yes.
One document.
Yes. Supplementary affidavit, which document?
My lord. Number 42. My lord, come to page number 42, no?
42. 42, yes.
42. 42, my lord, there are 4 plaintiffs, my lord.
What is this?
My
42?
lord, that is out of 4 plaintiffs, my lord, 3 plaintiffs had filed an order 23 rule 1 application below. Now, what the contention below?
In this suit?
Yes, below. In
Yes,
this suit.
yes.
Paragraph 3 below.
Yes.
That the plaintiff number 1, 3, 4, and 6 were compelled to sign the plaint and other applications without going through the contents of the same. In the plaint, there is suppression of material facts.
What happened to this application?
Well, that application is pending.
So I'm directing this application to be decided.
My lord, that should be decided, my lord.
Uh,
And my lord, if possible, my lord, with framing a preliminary point as to the maintainability, my lord.
Maintainability will be decided. Not preliminary cannot be done
Not
because
otherwise.
this application under Article 227 of the Constitution Next.
The matter number 213. Now. They appear for two.
Who is for the petitioner? Who is for the petitioner?
Your Lordship, this is my revisional application.
Yes.
Challenging two orders dated 18th November 2023 and 24th November 2023 and 18th of January 2024, Your Lordship.
Yes.
Your Lordship, by an order dated 24th of November 2023, the learned trial judge had granted visitation rights to the petitioner, Your Lordship, for meeting the minor child once a week and for teaching the minor child via virtual platform for 3 days a week. Your Lordship, that order has been blatantly violated.
If that is blatantly violated, you approach the learned trial judge.
Your Lordship, thereafter we had approached the learned trial court.
Yes, what happened
Your
after
Lordship,
that?
kindly seize the order dated.
Why are you not allowing the petition?
Your Lordship,
Kindly as a look at the order admitting the eviction.
Your Lordship,
My Lord Justice Raja Vasu Chaudhary.
Yes.
Now, my lord, what the father is doing, father is himself, my lord, violating this order. But why I say so, kindly sees the order admitting the revisional application. It's an order dated 31st of January 2025. Now, my lord, the father wanted to meet the child on the birthday. Lordship would record, my lord, see, my lord, my submission that, my lord, next page, that we did not object to it. Now, what the father is doing is, my lord, the direction was that the father and the grandparents would meet the child on the birthday. Father took 30 persons along with him.
No, Your Lordship.
The father took 30 persons along with him.
What is the order impugned? I'm not on that.
Lordship, there were two orders.
Order impugned.
The order dated, Your Lordship, 24/11/2023 of this.
24/11/2023 and 18th of January.
18th of January.
So, what has been done by that?
By an order dated 24th of November 2023.
But that was the
Visitation was
initial order,
initial
granting
order.
visitation rights to the child.
Yes, Your Lordship.
And
Thereafter,
what kindly comes to the next order, which my learned friend is assailing before your lordships.
what I am assailing is, Your Lordship, there is an observation being made. Similar petitions are being filed regularly, wasting the time of the court by the husband. Your Lordship, after hearing the petition dated 18/1/2023, this is my supplementary affidavit, Your Lordship. The order is over here, Your Lordship. If you Lordship kindly seize the order once passed by the learned trial judge.
Sorry.
This is a supplementary affidavit, Your Lordship.
So you have been allowed to meet on every Saturday at about 11:30 a.m.
Yes, Your Lordship.
Allowed to stay till 2 p.m. Where?
But in a restaurant,
in a restaurant in Kolani.
What the father is doing is bringing unwanted persons along with him to meet the child. And those persons are forcing the child.
Allowed to teach the daughter.
Yes, 3 days a week.
If they do so, you are at liberty to take steps. So what is the difficulty in this order?
Your Lordship, this order is not being complied with. We are
For
not.
that you take steps there.
Yes, Your Lordship. We have taken.
Why have you challenged this order? Why have you challenged this order?
Your Lordship, I'm telling Your Lordship. Your Lordship, after this, we had filed petitions before the learned trial judge. By an order, we had filed a petition on 18/1/2024. The next order that we have assailed.
Yes.
Your Lordship. If Your Lordship kindly sees the order dated 18/1/2024, there is an observation that similar petitions are being filed regularly, wasting the time of the court by the husband.
Yes.
Your Lordship, if your Lordship kindly sees this, my supplementary affidavit, Your Lordship will see the order.
Sir, what was the petition for?
The
That he will
petition.
take the child on Saturday, return on Sunday.
No.
Yes, Your Lordship.
That was rejected by the order dated 12th of November, 24th of November.
No, Your Lordship. If Your Lordship kindly sees the supplementary affidavit, the order is there.
Supplementary affidavit, which order is there?
The order rejecting my petition dated 18/1/2024. If Your Lordship kindly sees the order once, Your Lordship.
You did not press those applications.
No, no, your lordship.
9th of January, you did not press.
No, no, I am,
18th of January, what happened?
your lordship, my supplementary affidavit order dated 25/6/2024, your lordship. My supplementary affidavit, your lordship. Page number 8 of my supplementary affidavit, your lordship.
Kindly reads the first line of the order. My lord, the learned judge, my lord, interacted with the child. The child said, I don't want to meet my father because this is what
That
the
is
child
not
is
mentioned. That is not mentioned in the order itself, your lordship.
bringing unwanted person.
This is my contention that this is not mentioned, your lordship.
Saying that you must go and stay with the father.
No.
What is
Well, the first line is say the minor girl was asked by this court whether she wanted to stay with her father. Her answer was clear. What is the answer? That is not mentioned in the order, your lordship.
Yes, now you have been allowed to meet with the daughter. Please do so.
Your
Please
lordship,
see,
that-
My lord, kindly
please try to
restrain him, my
improve
lord.
the relationship.
He will
Then
improve, your lordship.
Kindly, my
And your
lord,
lordship,
restrain him, my lord, from bringing unwanted
another
persons.
prayer is, your lordship, kindly, if the petitioner is allowed to meet the minor child at least for 2 to 3 days in the week, your lord.
You file an application there.
We had filed an application, your lordship,
So
after.
you did not file an application to that effect. You have filed an application that we will take the child on Saturday,
Yes.
return it on Sunday.
Your lordship,
That was
this is the
rejected.
observation being made by the trial judge.
Has to be, because you are making
What-
the similar prayers
Your lordship,
repeatedly.
what the petitioner has done.
This application under Article 227 Yes, Mr. Banerjee.
Not the a non-party appellant is the petitioner before your lordship. Non-party appellant in a suit for injunction. No, my lord, fact is this, not the opposite party number 1 filed this suit against the opposite party number 2 to 4.
Opposite party number 1 filed against opposite party number 2 to 4.
3 and 4. Now 2, 3 and 4 my lord have engaged me as a developer to develop the property. I have invested not money, I have obtained the plan, I have started the work, then the suit was filed. So I am an interested party. What happened, my lord, the property was partitioned. There is no dispute regarding partition. One portion, front portion, one portion is not joint. The rest, my lord, is separate. Now they say that if you construct my buildings, there shall be damage to my building, so you cannot construct. This was some substance of the suit. Trial court, although observed that if I pass an injunction, then the defendant may be prejudiced, but still may not pass an order of status quo over the entire property. Not only not the joint portion, but the entire property.
If the demolition is carried out, if there is a something of threat of any damage to be caused, Mr.
To that, to that, they have filed a writ petition on the same ground. The writ court entertained and said, all right, you are aggrieved. I am directing, let the municipality appoint a structural engineer who shall file his report whether at all any damage shall take place or not. Municipality engaged a structural engineer, cost to be borne by the parties. I immediately may not paid the entire share of the structural engineer. He did not pay because he has got the injunction now. He did not pay. The municipality filed a report that because of non-cooperation of this person, he wanted the inspection and his property to be preserved. He did not pay the money, so he could not do the inspection of the structural engineer. On that ground, matter was taken up. The court was took it very seriously. Say you pay the money or I'll dismiss your writ. This is the position. But so far as the portion, joint portion is concerned, in the suit,
now what are you challenging?
Challenging two orders: order of the trial court by which injunction has been passed over the entire property, and I preferred an appeal saying that in the written statement it was disclosed that I am a developer, I have been engaged, and there's an agreement. There's a coordinate bench judgment which says that if such facts are disclosed, the developer becomes a necessary.
So your prayer for leave to prefer an appeal is rejected.
No, it was not rejected, my lord.
It says
appeal was admitted.
Question of granting leave for instituting the
that is a mistake committed. Appeal was admitted.
Application is considered and dismissed.
Just kindly see the previous order. The appeal was admitted by the court. Kindly see the previous page. Order number 1.
Banerjee, if this type of a property, common roof, common wall,
no, it is not common roof.
Banerjee, I dealt with a similar type of a writ petition. They are also in a writ petition. I appointed a structural engineer of our panel.
So they are not cooperating. Similar thing was done by the writ court. Let me finish. You will get your chota. Same order was passed by the writ court. Now he did not pay the amount for the structural engineer, so it could not be ascertained. By this way, he is stalling the construction work. Now, my lord, kindly see. Lordship will kindly comes once to page 110.
Mr. Banerjee, can this injunction be vacated? Then
no, what I am saying. But I am firstly, my lord, injunction, it should be vacated as per this coordinate bench judgment, because my lord, it says if you don't add a necessary party, the developer, this court, my lord, added the developer, send the matter back after vacating, saying that he was a necessary party. It was within your knowledge that he is a necessary party. You did not add him, and you passed the injunction. This is one.
Banerjee, you are an agent. If the principal is already a party, is it necessary for you to be implicated?
No, that is not your lordship's court's view, my lord. That is the view of your lordship.
Maybe you have a right to be added
I have a right
or not, but the suit cannot be dismissed on
No,
that.
I am not saying the suit
You
be
may have
dismissed.
certain rights. You may have acquired certain rights.
True.
So you have not, by virtue of a development agreement, but this is a suit interest between the owners. So whatever right you have with your principal, to deal with that. No dispute with regard to that.
So
what is the nature of the suit? Injunction.
Declaration and injunction.
Declaration of
not his right.
In that sense, you are not a necessary party, Mr. Banerjee.
No, injunction. If not injunction is not granted, he is asking for.
Not a necessary party in the suit.
No, that is not affecting my rights. That is not.
You do not have any independent right, Mr. Banerjee. Your right flows from the right of your principal. You cannot have a better right than your principal.
Not a, the court came to the finding that he is the proper party. But
Banerjee, I have decided an injunction application in similar lines. Developer, no.
Lordship will kindly once, Lord, then kindly go through this order of your Lordship's coordinate bench, Lord. Same set of facts.
I have also decided on this. I'm bound by my own judgment also.
Now, Lord, may I?
Banerjee, you are nothing. Your relation between your principal, who is a co-sharer or a co-owner, by whatever name you call, is that of a principal and agent. So you do not have any absolute right in the property. Maybe for the purpose of developing, you will be getting some share. So you do not have any interest in the land. You do not have any interest in the land, so you do not have any interest of the property.
I'll have an interest on the developed property.
Yes. So if you can develop the property, you will have something.
So
But you do not have any interest in the land pursuant to the development agreement also.
Now, Milord,
So you cannot be said to be
kindly see, Milord, if Milord an order is passed in the suit saying that no, you're injuncted from making any construction, that affects
This
my
is
right.
to be heard. I will hear this.
Lordship will
Cannot be
kindly-
vacated, Mr.
I'm not asking for vacation. I'll just not show one thing, one paragraph from the written statement, and I'll pray for Milord Lordship, since it is only one portion is attached, without touching that portion, Lordship will appoint a special officer. I'll request your Lordship to appoint a special officer without touching
Banerjee,
the joint
said
portion.
that effort has proved to be futile.
No.
The Reed Court has said.
Reed Court has directed an engineer to be appointed that if it is the joint portion is demolished, the property is not Sriampur. If it is attached portion is demolished, whether his portion will be damaged or not. That is, I am not touching the attached
Mr.
portion.
Banerjee,
I'm not touching that portion.
In a similar matter, I have seen the report. Several precautions are to be taken.
Lordship, yes.
Several
That is-
precautions are to be taken. You cannot touch that common wall, roof also. You have to
Lordship
leave a space.
Absolutely. Your Lordship,
That and demolition has to be carried out in a process.
I shall not
Because I have appointed in that matter, a structural engineer was appointed. He gave a detailed report and how that demolition will have to be made by what means. Detailed report.
we
It's very
abide by everything. We shall abide by everything, but not the entire project has been stalled. Can that be done, Milord? Kindly, because he has no right over my property. It's a partition property. He is not claiming any right, only damage to his property.
Yes.
So that has to be taken care of.
Yes.
Kindly comes now,
Because
Milord.
some portion is joint, Mr. Banerjee.
Yes.
That's the
We shall
difficulty.
not touch that portion at all. That is my understanding.
Maybe you are saying it's a partition. Maybe physically it's separate, but there must be some common wall and some common roof.
No, there is no common wall on the ground floor. Milord, first floor, Milord, the roof is joint.
Yes.
So that portion shall not be touched at all. But the back
How do you
portion.
say we will not touch the, we will not demolish the
Kindly
first
come
floor?
to page 110 once, Milord. Page 110.
Yes, now what do you want now? What order you are challenging?
I am challenging the order by which, Milord, my leave to appeal has been rejected after admission, after allowing it. Order number 1 says the appeal is admitted. The next
What is your owner doing? Your principal?
Principal contested, Milord, the suit. Written statement was filed. In the written statement, undertaking was
Contested the
given.
suit or the contested
In
the
the
injunction?
injunction also, their written objection was filed. Specific case was that we shall not damage any portion of his property, and if the court directs, we can keep our money secured. That if any damage occurs, it can be reconstructed. That was the undertaking given in the written objection.
Very difficult. You are saying once damage, and while demolition, if anything
Yes.
happens,
No, I am
will
saying,
happen to
I'm
that.
saying I shall not demolish. I want to show your Lordship the photo sketch map once.
What happened
110.
to the writ petition, Mr. Banerjee?
The petition is pending, Milord.
When it
they
is
did not-
scheduled to be taken up?
Maybe Milord, next week. She's giving the date. Lordship,
Try to obtain
kindly
an
come-
order there because, Mr. Banerjee, I tell you, there are very many things.
They are avoiding
First is-
that.
First is structural engineer's report, how to be demolished. Even after that, it's the municipality who has to either grant or refuse permission to demolish. Without that, nothing remains. You cannot do anything.
6th and 13th of August. Writ petition.
So I'm keeping it in the next week.
After that, I just wanted to show your Lordship the photo. Lordship kindly comes to page 110 once, Milord. Page 110, your Lordship will find, Milord. There's TP Bhattacharya Street, your Lordship will find. Now, Milord, there are portions marked A and B, which are, Milord, the portion of the my principal, and C portion is, Milord, belonging to them. Now, only, Milord, the front portion, there is one part which is attached. After that, there's a long building, which is a wide passage.
There's no, connection between the two buildings.
Suit property, entire.
Suit property, the entire property, not my property, entire property has been injuncted that I cannot do anything. Although he doesn't claim any right over this property.
All right, I'm keeping it in the next week.
May I take one just one?
Sir, I'm adjourning it. I'm keeping it in the next week. I'm not.
Only on the thing, my lord, he's not proper. I don't say. The suit was my suit was filed in October 2023. 23. He has entered the development in 29 January 24. He knows everything. He's super. I'm sorry, the super customer. He's just observing what happened. What happened. When I got the order on 5th October, my lord, now he has entered his appearance. Say, I'm very difficult. First of all, now he is trying to just, my lord, my property. I'm sorry, Lossi, if it's touched, it will be demolished. If Lossi is absolutely right, my lord. My part will be, my lord, seriously damaged.
Sir, how do you say I'm absolutely right? I'm not a structural engineer. Maybe.
I'm
keeping it in the next week. Ashun, Mr. Banerjee. তিনটের সময় করে রাখবেন। The next matter.
Item number 74.
274. Who is appearing?
The apply for the petitioner managed services complete upon
Which item?
274.
You have served. Have you notified the other side?
Yes, my lord. Yes,
You
my
have
lord.
served, but you just fixed matter. You have not notified, madam.
Well, on the last occasion, my lord, they were appearing. Mr. Amit Khan was appearing for the respondent, my lord. This matter is pending for a long time, my lord. This will be
Pass
triggered.
over. Next.
277.
Lord, I will put the petition. The last hearing, my lord, your lordship was pleased to direct, my lord, to hand over the copy of the application for appointment of inventory commission.
Appointment of
inventory commission, suit for eviction.
Yes.
Well, I am the adopted daughter of the real owner of the property. Well, the defendant is
কি দিলেন? ঠিক Yes.
Suit for eviction, trespasser. At the time of evidence, one vital document, the original is not lying with the petitioner. The petitioner paid for the use of secondary evidence. That has been rejected by the learned court below. Challenging that order, we have the petitioner before lordship,
What is the document?
My lord, the affidavit which was, my lord, affirmed before the, my lord, executive magistrate at Assam, by which, my lord, the adoptive parents, my lord, declared that the adoption has been made in favor of the petitioner.
Where is the original?
Well, original is lying with the, my lord, suit property. Well, now that is under occupation of the defendant. That's why, my lord, I have
Where is
stated,
your evidence foundation for leading secondary evidence?
my lord, kindly page 50, my lord.
50.
50.
Yes, Mr. Bhattacharya.
Two things, my lord. In the
Yes, Mr. Microphone.
two things, my lord. In the self document, my lord. In the suit, the injunction application,
The plaint.
kindly comes to the plaint at page 23. They moved injunction application on the basis of Xerox copy, injunction refused. They moved an application by inventory commissioner that was turned down. That attend finality, no revision application was preferred. Now evidence completed. At the stage of argument, my lord, they filed an application for marking that as a secondary evidence.
Well, we filed a Xerox copy of that affidavit, my lord, since the, my lord, filing of the suit, my lord. But the original could not be produced, my lord, in view of the fact that this, my lord, not lying with the, my lord, petitioner, and it is, my lord, in the, my lord, suit premises. That's why, my lord, the inventory commissioner was paid for, my lord, to make an inventory whether document is lying. Because this is a vital piece of document.
That inventory was rejected. They did never.
Mr. Bhattacharya, in the evidence, they have given the foundation for leading secondary evidence. Where is the Supreme Court judgment on this?
At the argument stage,
judgment on a rent receipt.
At the argument stage, they are now trying to bring this.
Of a rent receipt. Where is that?
That is not that matter, but another judgment is there, my lord.
The Supreme Court judgment on this point, rent receipt, photocopy of the rent receipt was to be tendered into evidence. Objection was taken. If a forged rent receipt cannot be taken. Where is that? Please bring that. Not today. Yes, call the next matter.
323. Well, this is the same point, my lord, photocopies. This is a Supreme Court judgment, my lord. AIR 2007 Supreme Court, my lord. On the same, my lord, photocopies, my lord.
Rent receipt.
Photocopies of the document. Photocopies of the document. Paragraph, my lord, 8-9. Not rent receipt, my lord, but my lord, documents of the which are not in original photocopies.
All right, come tomorrow. I will consider this.
My lord. 2007.
Yes, Mr. Bhattacharya, please consider this.
Note on.
Who is opposing you?
I am opposing.
Yes.
Not really opposing.
I am renewing my prayer.
What is your prayer? I forgot.
Both the husband and wife, my lord, come before your lord. In this
Of course, please use the microphone.
Microphone.
Yes.
My friends tell me that if I talk in the room number 6,
can be hard
and be
yes.
big it. However, both the husband and wife appear before your lordship. What I am saying, for the interest of the child, my lord, it is necessary.
What is the impugned order?
Impugned order is visitation right.
Visitation right?
Visitation right.
No, that has not been denied.
No. that has not been denied, but
You want some additional visitation.
yes, I want to.
What is the
sort it out.
arrangement? What is the arrangement made in the impugned order?
That in কোথায় যেন?
2 hours every
Mall in,
second and fourth at South City Mall.
2 hours.
South City Mall.
Second and fourth Sunday at South City Mall.
Why, Mr.
A 4 years child.
4 years, Mr. Ghosh, you may not be knowing, your juniors know it better. I think those places, playing zone and other things are there. No, what is according to you is a better place. What is
That's why, my lord,
what is the better place according to
no,
you?
not better. Better place, my lord, I shall come to later. My lord, what I am proposing is this: you meet both the husband and wife
With the child.
with the child. Then your lordship will find, and because in this case, my lord, medical science says that without the aid of the both father and mother, he cannot recover. And it is just, my lord, at the earliest stage of autism, and not that the.
What is the suit for?
Suit that is it.
Guardians and what?
Restitution of conjugal rights.
That is the restitution of conjugal rights.
Guardians and what?
Guardians and what?
No, no matrimonial
No,
proceedings pending.
We have filed restitution of conjugal rights.
You are for the husband or the father. Yes, Mr. Bhattacharya,
There
for
is-
the sake of the child,
Well, I have to take specific because in the afternoon itself,
I can send it to mediation.
that
Mr. Ghosh, it's better.
My lord, it's better, my lord.
Better, Mr. Ghosh, I am saying mediation will be
No, no.
better. And if you want, I think that facility is also there. If you want, considering the child's benefit, if the opinion of a child psychologist or counseling by him, is it necessary?
That already has been taken. Those are reports are there, my lord. We have filed that also in the trial course.
Let me show me the impugned order once. What do you want now?
That is, impugned order is, my lord, just
186.
visitation. Even that is, my lord, not taken care of. The wife, my lord, at her whims, my lord.
Mr. Bhattacharya, why are you not allowing the father to
My
meet the
my
child?
client, my
There
lord,
is there is visitation. Their specific order is there that has been going. He works 10 hours
Mr.
every
The
day.
order may be there. But please cooperate in this regard. Please don't obstruct the visit.
No, there is no.
After all, what Mr. Ghosh says, considering the mental health of the child, he says because he must be having some documents, medical documents in support to show that presence of both the parents is necessary for the development of the child. Why both of you are not cooperating for the development of the child? After all, it's the welfare of the child.
They have filed applications saying
Possibly, my lord,
10 hours every day. They wanted 10 hours every day. That
Mr.
But I'm not on this.
That might be a different thing. He might have paid for 10 hours, but considering the special circumstances, we do not know. What would be the better? What is the opinion of the doctor or the?
এটা দিয়েছে আমি
my lord, we have given.
ফোল্ড করেছে পেজটা ফোল্ড করা আছে
এটা কি দাদা দেবে একটু
Folded page.
দেবে এটা একটু
Folded?
page the one at the top my lord yes kindly sees my lord the impression the problems and the significance he's a child with special needs that is the issue my lord is not a very normal
Yes, that I appreciate, but what is to be done now? How this can be solved, Mr. Ghosh?
My lord, what I propose, my lord, is your lordship, may let the wife also appear, my client will also appear, along with the child. My lord, kindly take it up.
What I
Make
can
it
do?
fun.
Mr. Ghosh, what I can do?
impress
Because
upon
after all, what do you want me to do?
My lord, to request the wife also, and my client is their husband. Let them, my lord, make some arrangement, my lord, at your lordship's insistence.
So already there is arrangement. So there is
That has not
already
been followed, my lord, because
What arrangement
what
you
they call
want?
it,
What arrangement you want?
second and fourth Sunday.
only second and fourth Sunday, and that also not been complied with. He is a
Mr. Bhattacharya,
no,
this
only, my lord, not on Sunday. She is giving a other date, my lord, in the weekend.
No, the child is in school now.
My lord,
Yes,
kids
yes.
the school, 4 hours.
Kids is school. So Saturday and Sundays are holidays.
Yes. I am not aware whether any extracurricular activities are being, I will take instruction. for
Take
that.
instructions. So now the present arrangement is on Sundays.
Sundays.
Sundays, second and fourth.
Alternate Sunday.
Second and fourth
Yes.
at South City Mall.
South City.
South City Mall is a good place, I think.
That we discuss my lord, that we discuss and take the child. My prayer is for say state holidays and national holidays. That also.
That will come. First, please start with this. Sundays, Mr. Bhattacharya, please take instructions if it can be on all Sundays of the month.
He
Why
is also a
not?
malad serviceman.
I have to take instruction on that issue. What are the
On
difficulties?
Please take and what is the duration?
2 hours.
2 hours. So is it going on? 2 hours? It's happening.
2-3 hours. 2-3 hours it is happening.
2-3 hours it's happening.
Yes.
So Mr. Bhattacharya, if that is happening, why don't you increase it from 2 alternate Sundays to all Sundays? Then we can think of, because after all it's the welfare of the child. Why don't you agree to all Sundays for
Let me take instruction over this issue, my lord. Whatever
I'm fixing.
Whatever is let it continue, kindly keep this next week so that I can take a specific instruction over this issue, my lord. They have to ask me something also more. Let me convey my client also, because both are in loggerheads, my lord. That's the difficulty.
Bhattacharya, since you are here, Mr. Ghosh is there. They might be having some egos. They might be having some internal problems. But Mr. Ghosh, also please ask your client not to, for
My
the welfare
client
of
is
the child,
ready, my lord.
he has to be also reasonable. He has
My
to
lord,
be
my
open.
client is ready. He has filed for that, my lord. He has filed that suit for
Mr.
restitution.
Bhattacharya, please ask him, what's the real difficulty?
Let me inquire, my lord.
Please inquire, because after all, for the child, because as Mr. Ghosh says, that the child for the improvement, because he is in the early stage, as Mr. Ghosh has, if it can be improved, he can become a normal one with the attachment of both the father and the mother, maybe the paternal and maternal grandparents also. If all these things they combine together for the overall development, please instruct. Paternal grandparents are also there. Where are they staying?
Yes.
Where are they staying?
Ligarins. It's just
So in Kolkata.
in Kolkata.
And maternal grandparents.
I'm not aware.
Take instructions whether all this it can be done. I think will be better.
Possibly, my lord, my management doesn't know, because the intervention is coming from the other side's relatives.
That's the allegation.
No, not allegation.
Maybe allegation, according to you, it's allegation. Please see that that is not being done. End of the matter. Let us accept, yes, it is an allegation, not a correct state of affairs. So you prove that, come clean with that. Please, for the present, please increase the visitation from 2 alternate days. And if it can be, what is the time, from when?
So it depends, my lord, in the morning or sometimes in the evening. 2-3 hours it happens.
That can be arranged that mutually it can be decided.
And I also want
Actually,
may I humbly,
My lord, on the holiday.
my lord, also I want
Mr. Ghosh,
Because
must
my lord,
start.
weekdays, my lord, he will not be available. He is a employee of bank, na?
yes.
No, weekdays, I think the child will also be having schools. He will be tired. Saturdays and Sundays, we have to.
Management client, my lord, insisting on a weekday.
let me take instruction over the issue. Kindly fix this.
Can throw it from your-
He's a serviceman.
Kindly fix this next week so that I can come with a proper instruction.
He is also doing service. So practically, my lord, the child, my lord, is
So Saturdays and Sundays. So if on both these days it can be done, please consider that. If on both these days, and Mr. Ghosh, also you have to consider maybe on considering the health of the child. It may not be possible for 2 consecutive days also.
No.
Might be, it not.
My lord, no. My lord, first, my child is not special. Okay, he doesn't need any support, nothing. Whenever he sees me, he comes running to me. Matlab, you can see annexure, the pages.
And if both of you want, I can appoint a special officer also.
what you will do.
To oversee this,
you can
so that no problem is created.
My lord, you can check annexure M.
Problem is created my lord, from the backward side. That is the problem.
Please see, because please look into this.
But that's the
should not-
difficult.
It is better, my lord, if they both of them stay, my lord, in a secluded, separate accommodation. Then
Both of them means
why husband and wife?
Along with the child.
If my lord, the wife is
possible.
If my lord, the wife is so interested in the health of the child.
That's not probably not possible as per my instruction over phone. That will not be possible. I have to take
Because there are some other person poking, my lord.
Mr. Bhattaji, see, after all, if the relation improves.
That is the problem. Both of them
Right.
cannot use live in
I should definitely.
Both of you want, I can send it to the mediation. Mediator can also apprise the parties with regard to that. If both of you want, I can also send it to mediation.
Better, my lord.
Authority.
Mediation is better because they are equipped, trained mediators.
Doesn't mean, my lord, it has to be given to some other person. Your lordship can also.
They are trained mediators.
It will only take, my lord, half an hour or 1 hour.
Let me see how far Mr. Bhattacharya can impress upon his client.
Your lordship's chamber, my lord, I will be there.
That's not a problem, but let me see how, if the parties are agreeable, Mr. Ghosh.
My
can
client
be
is
done.
agreed. No problem.
Not one sided, it has to be both sided.
Now it is for my learned friend. my
Yes, when Mr. Bhattacharya.
Kindly keeps you 2 weeks hence, my lord. I shall.
2 weeks, why?
Let me take or can you next week? I shall come with a specific instruction to that.
Why 2 weeks, Mr. Bhattacharya, 2 weeks?
Kindly keeps next week in that event. I will come with
this Saturday, Sunday, this Sunday you have visitation. This Sunday you have visitation.
Sunday, my lord, see.
This Sunday
This Sunday I have, yes.
you have visitation. So
15th August also if permitted. So.
Look, I cannot commit, my lord. Kindly whatever fix.
Mr. Bhattacharya, I'm keeping it tomorrow. Please take instructions for this 15th of August, special day.
But kindly keeps it
Special day.
But kindly keeps it next week, my lord. Definitely.
Next week I will consider.
I am not on the issue, my lord. But kindly cease, my lord. I have to take instruction, my lord.
15th of August.
Sunday is there. There is
Sunday is there. What is the problem in getting one another extra day?
Instruction from your client or her relation?
No. Kindly
I'm keeping it tomorrow. Please take instructions. Whether it is on Friday, it can be possible. Independence Day, any time, subject to the only the convenience of the child is to be taken.
My lord.
Nothing. Nobody's convenience. Not the father, not the mother. What is the convenient time for the child?
And for the recovery from such type of illness, my lord.
That will take
both parents, my lord, presence is necessary. That is the medical science also says that.
I have to take instruction whether he has any difficulty or not, that has to be also be considered.
Please consider that, and for the present 15th of August.
Well, let it be taken as a first matter tomorrow.
First matter, why?
Miss the bus, my lord. If we miss the bus, then my lord, 15th hours is just one day only.
What you will miss the bus?
Yes.
But tomorrow is 13th, there 14th is
Because
another
stop
day.
the bus.
Not in our abilities.
Nothing will happen. If anything, please mention.
My lord. Affidavit of sir.
Copy this.
Every service filed in court today is taken on.
বাচ্চাটার জন্য তো মায়েরও এ হবে।
Yes.
তারই তো বাচ্চা নাকি?
Yes.
Item number 361.
Lord, on last occasion, Lordship asked me, my lord, to submit.
Leaving my lord in August company
Yes.
of Progu.
Yes, Mr. Nag.
Now, my lord, Lordship asked me, my lord, to see, my lord, how, my lord, the judge look into the judgment and who has relied the judge. My lord, I gone through the records. My lord, lot of statements have been made, my lord, from the bar. So I asked for the entire record to be placed before your lordship, or so that, my lord, the situation may be clear. My lord, I have filed a rejoinder. Where is the rejoinder? I have filed a rejoinder. That rejoinder copy they have, but they have not disclosed. Now, my lord, in the copy of the rejoinder, my lord, I'm giving him a copy.
How much time it will take, Mr. Nag?
10 minutes. 10 minutes.
10 minutes
Take the
today. Mr. Nag, today 10 minutes is a problem because I have.
Maybe, my lord, just, my lord, if Mr. Bhattacharya allows me, only I can wrap it up in 5 minutes.
Oh, only one. This rejoinder was never served on us. They didn't show that it was
It was served. It was served. There is a signature. I will also show the order, and which, my lord, it shows, my lord, that they have received it from there. My lord, OP number 1 and OP number 2, my lord, received it.
Where is the signature?
In the bottom,
There are two signatures.
Yes, one
Ranjit
OP1.
Mahato and another is.
Yes, OP1 and OP2 also, my lord. They have.
Yes, advocate for the OP2.
Yes.
It's you are OP1 or OP2, Mr. Bhattacharya?
OP1 also, this Mahato is the.
Mahato is OP1. Its signature is there, Mr. Bhattacharya.
Yes. Now, my lord, here, my lord, the short question is.
Well, I have to take it.
My lord, allow me to complete, my lord, then he can interrupt. Now, my lord, here, my lord, no judgment was disclosed. Lordship sees no judgment was disclosed. Lordship will find. So the question of them relying on a judgment, relying on me, judgment, they should get a chance to rebut a judgment, does not arise. Now the question is whether a judge on his own while writing judgment can give a citation or not, well, rely on a judgment or not. On this regard, I am relying on a judgment reported in 2012, volume 348 ITR. Well, just 2 paragraphs. Well, both ultimately became the Chief Justice of India. Lordship sees paragraph 4, 3 and 4. Learned counsel for the petitioner, Geoffin, submits that learned tribunal heard in dismissing the appeal, as the tribunal in its order had referred to and relied upon the decision of another income tax appellate tribunal bench, which has not been cited at the time of hearing. So that judgment, he submits that the order passed by the tribunal under section such and such should be recorded. We do not find any merit in the said contention. Under section, mistake apparent on the record can be rectified. The power circumstances limited. There should be a mistake which apparent before the power can be exercised. This is a mandatory precondition. The tribunal in its order referred to the controversy in question. Disallowance made on account of short-term capital gains. The entire issue was examined merits. After examining the matter in detail, the tribunal allowed the appeal filed. While allowing the appeal, the tribunal also referred to another decision in such and such, in the case of such and such. Reliance and reference to reasons stated in McIntosh Supra cannot be regarded as a mistake apparent from the record. It is not unusual or abnormal
for the judges or adjudicators to refer and rely upon judgment decision after making their own research. So the issue closes. Now, my lord, just to wrap up my submission before your lordship, I says that, my lord, on last occasion there is no patent illegality because I have taken a view that may be illegal, but that cannot be patently illegal. Now, my lord, just for my sake, my lord, here, my lord, selective orders have been disclosed. My lord, kindly have a look at the order sheets, at a copy of the order sheets now. My lord, kindly look at the order sheets. I don't find what sort of more hearing they required. The entire order sheet that is not disclosed. My lord, now, my lord, first day is 20th May 2025. Order number 39. My lord, on day issue was issued. My lord, the notice was issued. Not really well. Next paragraph. Next page, kindly come. It is reply, order of reply pass and direction was service for pass. Next is important. Order number 40. May I just place it? Matter is taken up for hearing. One S.D. Banerjee, learned advocate, appears in the forum on behalf of Sotto Doctor, that is the OP2. Well, leave first three paragraphs. Kindly come to paragraph number 4. That during the course of hearing, one C. Prasad also appears before this forum, expressing himself as a peon working in Martin Bond Limited and files an application. Let such application be kept on record. We allow the peon even. On perusal of said application, it is seen OP had prayed for time to file reply to show cause notice such and such. Consider the matter. OP is directed to file the reply to show cause notice on such and such within the next date. A copy of the application has to be served. So, well, direction was passed. Next day, well, kindly takes. Well, next day was 3rd June 2025. Matter was taken up for the hearing. The representative of OP files to show cause notice. Let the same be kept on record. The learned advocate appearing on behalf of Sotto Doctor Social Welfare Association also files the reply to show cause notice. Let such reply be kept on record. A copy of both reply filed on behalf of OP and Sotto Doctors will be handed over to the representative. SMPK directed to file their comment. So, reply filed in terms of that. Section 7 only, mandate a reply has to be filed. Then, next order, 10 June 2025, also not disclosing civil divisional application. Matter is taken up, stop this running commentary. Matter is taken up for hearing. The representative of SMPK files their separate comments with regard to reply filed by OP and Sotto Doctor. Let the same be kept on record. A copy of 2 comments have been handed over to the representative of OP and learned advocate for Sotto Doctor. Rejoinder, disclose signature, 2 signatures. He said, I have not received 2 signatures, left hand side lordship will find in the order itself. In view of the matter, let the matter come up for final hearing on the next day. Parties are directed to collect the certified copy of the order. So matter was fixed for hearing. But on that day, no prayer was made for filing application or something. Next ballot, next day is 17 June. Again, on that day, lordship will file. Matter, no, before 17 June, lordship kindly come to page 101 of your lordship's brief. Oh, this is the 17th June. Kindly have a look at 17th June or also can look into that. Matter was fixed today for final hearing. Accordingly, the parties were directed to place their verbal submission. So, verbal submission was asked. On that day, there was no application on board. The learned advocate on behalf of Martin Bond, Sotto Doctor added party had placed their respective verbal submissions. So, verbal submission made. The representative of SMPK had submitted that they had already filed documents in support of contention and would rely on that. However, during the course of hearing, the learned on behalf of Sotto Doctor had filed their reply with regard to SMPK's copy. A copy of said reply filed on Sotto Doctor was handed over to the representative and SMPK. Further, learned advocates, when after conclusion of hearing, learned advocate on behalf of Martin Bond filed an application praying for adjournment to file an application. An application adjournment was filed for filing an application. The application was not on board on that day. Peruse the application filed on behalf of Martin Bond. Hearing considered the matter, it is seen from the records that both OP and the added party has already filed their respective reply to show cause notices dated such and such. Subsequently, SMPK has also filed their comments with regard to the same. Therefore, in view thereof, hearing of the matter is completed. So, my lord, somebody files opposition, somebody files reply, matter is fixed for hearing. On that day, somebody comes and saying, adjourn the matter because
17 June 2025 order is under challenge.
no, it's not under challenge. The order under challenge is the final order which was passed. No, submissions were made from bar saying that as if the proceeding is a farce, there was no process followed, there was no hearing, and when a judgment was placed from the bar, that was copy not given. My lord, all figment of imagination. My lord, to be sure, my lord, as an officer, I asked for all the records to be brought so that I can see and submit something. Because I never encourage, my lord, the submissions from bar. And my lord, creating a legal, my lord, facade and making argument. So, my lord, the point of natural justice, my lord, where, my lord, there was a show cause, they gave reply, I gave comment.
When can you come back?
At any day convenient. Well, I have nothing to say, man.
You have concluded.
Concluded.
How much time?
I have concluded. On the point of maintainability, I say natural justice I have covered, patent illegality I have covered.
So, how much time you will take? Today I have a difficulty.
Today at 4 p.m. will not keeps it Monday.
Monday 3:30 also. Monday is also.
Next Wednesday. It comments to your lordship.
Next Wednesday here.
আমাকে নিজে ফোন করে বলেছে সকালবেলা যে এই সাবমিশনটা রাখতে।
Also, I could have taken up because today I have a difficulty. I have a meeting. That is why I could have continued.
There is a huge claim, and they are enjoying interim order. Without CQA, he is enjoying
21st. Asun, Mr. Nag.
In the meantime,
What is that? Oh, that is the maintainability. Maintainability. So you have your written notes.
in the meantime, the coercive
That is already there.
One sentence.
How much time? You have your notes ready.
Well, one thing, one indulgence. May I seek one indulgence? Well, kindly record my submission or I will be in suit.
All right.
But then I asked for a condition. I know. অর্ডারটাও আমি লিখে দিই না
Who?
এই জন্য অডিক বলে মানে রোলেক্স ছুড়ে মারবে।
Your advocates have come from Bombay today. Sir told me, Mr. Bose. This marked at 4 p.m. because, but it was continuing. That matter was also 4 p.m. 3 p.m. This matter was also 4 p.m. because I thought they told they will take 5 minutes.
I took only 5
Yesterday.
minutes.
His get sometime tomorrow, anytime.
Tomorrow you have 3:30. That is the difficulty.
কাল পরশু সোমবার 3 মিনিট 3:30 আছে মনে হয়।
Huh? How much time both of you will take?
It shouldn't take 20
কালকে সোয়া 3টে 3:15 tomorrow.